Good morning, everyone. Happy Friday. Well, today marks day 3 in the trial of the 17-year-old Collin Griffith, who stands accused of the September 2024 murder of his mother, 39-year-old Catherine Griffith, in Auburndale. Griffith has been charged with first-degree murder and kidnapping and is being tried as an adult. In the earlier proceedings, the jury was presented with Griffith's 911 call in which he claimed that his mother had fallen on a knife during an altercation. However, the medical examiner testified that injuries were inconsistent with this account, suggesting a more deliberate act. The prosecution has portrayed Griffith of having a history of violent behavior. Yes, it seems to appear this way. I'd love to know your thoughts on this one. Notably, in 2023, he was involved in a fatal shooting of his father in Oklahoma, a case where charges were eventually dropped due to the claims of self-defense. As we move in today's session, the court is expected to hear from some key witnesses, including maybe bringing, I think they dismissed all the neighbors. I know there was only a few who allegedly observed Collin dragging his mom by her hair shortly before the incidents. I know we left off yesterday with the, I cannot talk, it's still early. TGIF. But they left with Detective Peters on the stand. And there was quite a bit of getting spicy in there in regards to having access to cell phone. So I'm going to go ahead and we're going to get ready to take you into the courtroom. There's Collin. Okay, we're getting ready to proceed. He seems to me very confident. So that's just what I've gotten so far. Yesterday, I kind of got some vibes. You couldn't see him, but I was getting some vibes like maybe he was getting angry. I don't know. We'll wait and see. Court should be starting in just a minute.
Presiding.
You may be seated. Good morning. computer is black. That's not a good sign. It has been one of those mornings.
Judge, I hear ya. It's been one of those mornings. Good morning.
Hey, can you call IT? My computer suddenly will not power on.
Well, it looks like there is some tech difficulties. Never seen a judge on a telephone before.
Mr. Levine is here for the state. The jury is on the way up. Mr. Hertel tells me, but before that, do either of you have any authority on the issue that we were discussing yesterday?
I do, Your Honor. I found a couple cases that seem quite illuminating. Your Honor, beginning with Tallman v. State, for the record, that's 120 Southern 3rd, 593. Tallman is spelled Tallman. And on page 1 and 2, it mentions that a juvenile does not have the right to exclude a parent from access or control over his or her personal belongings. To hold as such would undermine the inherent authority of a parent. The second case, State v. SD. For the record, that is 758 Southern 2nd, 1253. Has a similar holding, including, we hold that by virtue of his parental authority, the father's consent overrides the juvenile's objection. And then it talks about some of the rationale behind that, including a father has the responsibility and authority for the discipline, training, and control of his children. In the exercise of his parental authority, a father has full access to the room set aside for his son for purposes of fulfilling his right and duty to control his son's social behavior and obtain obedience. When a parent basically, the parent can, like the first case said, can do as they see fit. The parent is exercising his or her parental authority and control over the unemancipated minor child. So I would submit that those two cases coincide with one of the court's inquiry regarding that subject matter, Your Honor, and that would further support the finding that the text message in conjunction with the attorney-client privilege law and argument and subject matter we discussed, that should be admissible, Your Honor.
And did you place the case names on the record yet?
Yes, Your Honor.
You did. All right. Ms. Thornhill?
I have a response, as well as some cases, but I'll get to them if that's all right.
All right.
First, I found no authority that talks about a parent's unlimited right to go through everything. I understand the cases that Mr. Levine cited in connection with the Fourth Amendment issue, but of course we're dealing with a different issue slightly. So, parental rights assume that the parent is acting in the best interest of the child. I think that's the foundation. But the child also has rights vis-a-vis the parents, and those rights change over time with the age of the child, right? So a 2-year-old or a 4-year-old, obviously a parent has much more control and much more ability and authority to intervene in their child's behavior, their belongings. As the child gets older, the child's rights increase in relation to their parents. At any rate, even if you find that this mother, Kathy Griffith, had the right to snoop or right to go through Collin's cell phone, I still have arguments that relate to his right under the Fifth Amendment and his Sixth Amendment and his privilege to communicate privately with his attorney. So first, the privilege is only waived if at the time the communication was made, Collin intended it to be disclosed. And you mentioned, should he known or should have known that his mom might look. That's possible, but we still have to look at his intent and then what the mother did with her, I'm going to call it snooping, looking. When we talk about people who are in jail, inmates, even though they have very restricted liberties and their right to privacy is severely curtailed, there is still a means by which they can communicate privately with their lawyer, right? So we have attorney booths at our jail that are private, are not monitored. So they have that ability to exercise their privilege. If an inmate makes a choice to call their attorney from the monitored line, say just call on the phone, they are warned at the outset. This is being recorded and monitored. Anything you say is not private. And if they choose to use that phone, then shame on them and the privilege is waived. But the important thing is that they have a feasible option to exercise their confidentiality privilege. But what choice did Collin have? We talked about this. Could he have made a phone call? As you pointed out, there are surveillance cameras everywhere in the house that could have picked it up. Could he have gone to his attorney's office? He didn't drive, he didn't have a license. Could he have called his grandmother in another county? Possibly, but is that reasonable? A child has restricted agency by virtue of them being a child. He didn't have any other feasible options. And I don't think a child should have to give up a privilege because they are a child, which is essentially what the state's wanting you to find, is that unless the child can somehow on their own, or if their parent's not willing to cooperate, can get to their attorney's office and go inside the office without their parent, then they can't exercise their privilege. It's like putting the burden on the child to do something extra to preserve a privilege that other people have easier access to, which seems unfair. But in addition to that, Judge, I may have been wrong in how I deal with parents who want to be present in privileged conversations. Because the case law indicates that due to parental authority, that also includes duty, because parents are close advisors, and it's natural that a child would seek advice from a parent, and that a parent would want to be involved to some extent in making sure that their child is represented adequately, also to facilitate the communications, so driving the child to the office, providing the phone by which the child could call their attorney. There is a case that I found, nothing in Florida that's directly on point with this particular issue. It's Doe versus Town of Greenwich. It's 473 Federal Supplement 54. It's from the District of Connecticut from 2020. a brief rundown of the facts. Two minors had an interaction where the female alleged that the male had attacked her, had sexually assaulted her. It's not a criminal case. The girl's family, on her behalf, sued the town of Greenwich, saying that they had not provided adequate supervision and investigated the criminal case adequately. So that's kind of neither here nor there. At any rate, the suit was between the girl and her family and the town. The girl's family, and it's unclear how they got these emails, but they obtained emails between the boy, now he was a non-party, but the boy and his lawyer and the boy and his headmaster from his school that discussed what he had discussed with his lawyer. All right, so the kid himself actually disclosed to a third person, his headmaster, communications between him and his lawyer. And the federal district court held that even though the other side already had them, and even though the child had purposely, so very different than what we have here, purposely told somebody about those communications and shared them, that the attorney-client privilege still existed and that those communications were not admissible in court. So a couple things with this case. The court found, they talk about how minors are treated differently than adults out of a recognition that they do not always know, due to lack of maturity and world experience, what it is they should be doing or not doing. And given the various protections afforded minors in the law, it seems particularly harsh to summarily find that Roe, the boy, waived his attorney-client privilege when he shared privileged communications with his headmaster. During the investigation, Roe, the boy, was 16 years old. There was an investigation into his behaviors that left him scared and anxious, and it's clear that he considered his headmaster to be a friend and source of guidance and support. It goes on to say that under the circumstances presented, the court concludes that Roe did not waive his attorney-client privilege by virtue of his disclosures to the headmaster. So it talks about the protection of children and their rights, given their unique positions as sort of subservient to adults in their life. I would argue that the headmaster is analogous to Kathy Griffith. It's not a completely on point analogy, but Collin communicating with his lawyer and knowing that his mom might find it doesn't excuse, and this is something that this case also discusses, doesn't excuse what the mom does with it later. And that's my second point. That's that, okay, so maybe you find she had an absolute right to look through his communications with his lawyer. Or maybe, as her duty as a parent, once she realized they were privileged communications, she has a duty to act in the best interests of the child and not go sharing those with other people. And certainly that shouldn't translate to, if she does make the bad decision to breach the attorney-client privilege, to allow it to be admissible in a court of law against her child. She also was the alleged victim in that particular case. So she bears some responsibility in doing what's best for Collin. I think she violated that duty by sending it on. And even though the cat's out of the bag now, I don't think that her maybe having a right to go through clearly privileged communications gives the state the right to use that in this criminal case. She was parent has to act in the child's best interest, as I said. But even if you're engaging in some weighing of the rights and responsibilities and duties and, the duty of a child to obey their parent, it doesn't wipe away the privilege that exists. I provided RLR 116 Southern 3rd 570 from the 3rd District Court of Appeal in 2013.
You have not given me that yet.
No, I gave it to you at the hearing,
Oh,
but I'll give it to you again. It basically talks about, even if it would be in the best interest of the child to deem the privilege waived, in this case it was for the protection of the child, it still means you can't violate the attorney-client privilege. Additionally, under Florida statute section 90.5021C2, talks about that disclosures to third persons who are necessary to the communication between the defendant and the lawyer, or between the client and the lawyer, are not waived from the privilege. So if you accept the state's position that the mom had every right to do everything she wanted with her kid, but she is the only way, or the sole way, that can facilitate the communication between Collin and his lawyer, and she's the one who controls the phone, apparently, then even if she found the message rightfully, it still doesn't mean that it's waived. And she doesn't have the right to waive his privilege, even if she is in a position of authority over him. The privilege belongs to Collin. I'm almost done, I promise. Then we also, sort of as a logical argument or an overarching view, if you decide that Collin waived his attorney-client privilege by using a phone that his mother controlled and had the right to look into, if you take that to the logical extension of it, then how is a kid ever supposed to communicate privately with their lawyer unless their parent can facilitate it, in which case then they would never have the right, because their parent would be the third person that was involved, which I think completely vitiates the purpose of the attorney-client privilege and should not be a ruling.
all right, so Ms. Thornhill, I had essentially come to a very similar conclusion as yours, agreeing with you. First of all, recognizing I believe the law is clear that a parent has the absolute right to determine what extent the child will have privacy in that relationship. But I agree with you that there's an overarching duty of the parent to act in the child's best interest. And when a child is facing legal jeopardy, that would, and that's recognized across divisions of court, dependency court, family court, criminal court, a parent has a duty to act in the best interest of their child. And that's probably, in fact, why that absolute right of surveillance exists, so that you know what your child is getting into. Or is being exposed to, so that you can make the decisions about guiding that child, providing the appropriate services, and so forth. So the right and the responsibility go hand in hand. And I think that's something that we fail to recognize across the penumbra of rights that we have these days, that they come with responsibilities. So I agree fundamentally that a parent, when it comes to an evidentiary privilege, meaning those secrets that they find in the locked box being what would otherwise be subject to a claim of privilege, that parent has a duty to act in the child's best interest with respect to those secrets, even when the parent is at odds with the child with respect to those secrets. Now, that's not to say I don't believe the parent cannot act on those secrets. For instance, call law enforcement, separate herself from the child, even initiate a Baker Act, file criminal charges. But what I have a hard time with is that once that child is sitting here in front of a judge and a jury, whether that circumstance could ever operate to waive the claim of privilege, when it is just the parent who it was exposed to. But Mr. Levine presented me this case, and I need you to tell me how it's different, because although it's a Fourth Amendment case, that evidence would have been suppressed. Otherwise, that evidence would have been suppressed if the parent did not have a right to consent to a waiver of an important constitutional right, which is to be free from unreasonable searches and seizures and have that evidence used against you in court. How is this different? Because in essence, it's sort of the same. And that's the law in Florida. A parent can consent to the search of a child's bedroom, and that had not even crossed my mind during our discussion. So what is the difference here? It's evidence being used against a child in court. One, it's okay, and one, you're saying, and I initially, through my thought process overnight, agree. But what do we do with that case?
I think that those situations are distinguishable because the government is acting, right? Your Fourth Amendment right is against the government from engaging in unreasonable searches and seizures. And when the government comes and says, I want to search your kid's room, the parent, as the parent with rights and responsibilities, and maybe not knowing what's in the room, because if the parent had snooped and known what was in the room, then they would have a duty to do with it what they thought was best for their child, right? But here we're dealing with a government actor intruding on a private place that the parent pays for, that the kid is has some duties towards the parent too, and the parent can say, all right, government, come into my house and search, right? That's very different than a mother who on her own has the duty to protect her child, the duty to act in the child's best interest, who goes looking through their private communications and then shares it with people, okay? It's another thing. Even if Collin knew his mom was going to look at it, if she's facilitating the communications, that doesn't mean he intended it to be disclosed to everyone and be used against him. So I think that because
It's a specific privilege, it's not directly on point.
because the government wasn't acting at the time here, and mom took it upon herself to totally destroy his attorney-client privilege by sending it to Susan, and then Susan, maybe by accident or not knowing the implications, then turned her phone over to law enforcement. I think that's too many steps removed from a government actor coming to a home that the parent owns and controls and says, can we search your kid's room?
So what about the circumstance where the state issues an investigative subpoena to mom and says, tell me what's in that phone, and the mom willingly complies? How is that different? And says, yeah, in his phone he said he was going to stab me in the neck, to his lawyer. And then
I
we
still
talk-
think it would be privileged.
But
but-
how is it different?
Hold on.
They're both essentially at their core evidentiary privileges. I mean, I think unreasonable search and seizure is broader and protects individuals' privacy as well, but it also is subject to the rule of exclusion if there is an unreasonable search and seizure. So at its core, it's an evidentiary.
Well, but
issue.
we're also dealing with something a little bit different in that we're dealing with a privilege of confidentiality, which is different than living in your bedroom, right? So for instance, with the psychotherapy patient privilege, a parent can't waive that on behalf of their child, even if they know what happens in those therapy sessions, because it's the child's right to confidentiality in certain things. And there are very few
So it's
privileges.
because the child doesn't own the bedroom, that it's different, is what you're saying?
No,
Because
not
it's
entirely.
the parent's right to determine who has access to what they own.
No, the law doesn't provide a child an absolute privilege like it does in their bedroom, like it does between a lawyer and the child as a client. We have to start from that place, not the backpack he's carrying, the room he lives in, where a government actor is trying to find something. We're dealing with the privilege exists. Very few privileges exist that keep things completely confidential. This is one of them.
And so, Mr. Levine, you have a response to that, the consent to search a bedroom is different than consent to give up confidential attorney-client communications.
Yes, it's not, Your Honor. I mean, both are evidentiary issues at their core, because ultimately the state is trying to use evidence, however it was obtained, and I submit that it was obtained lawfully. What Kathy did was not illegal or diabolical. It was Susan Detman, which I think is beside the point, but nonetheless, it was Susan Detman who consented to giving her phone and that information to law enforcement. It wasn't like Kathy, who would have been within her right to go to law enforcement and say, look at this, my son is saying he's going to stab me in the neck, and he's already killed his dad in Oklahoma. And the only reason I say that is because obviously the jury's not here. So it's not like...
Now remember, I didn't say she couldn't use it, like for purposes of protecting herself, getting him services, whatever it may be. I didn't say she couldn't use attorney-client communications for other purposes. The issue is whether that means she can consent to waive the confidential nature of the communication in a court of law.
No, nobody's waiving the communication for him.
Well, that's essentially what I would be doing, is saying because a parent's absolute right to surveil their child exists, that every child knows or should have known their parent can find it, and thus it's waived.
No, I don't think it's that broad, John. But in terms of the admissibility, there's reasons and court findings, including some of the cases I gave you, or the general topic matter, where the attorney-client privilege, the evidence comes in court. If it was such an absolute right, then there wouldn't be any case law, and there wouldn't be instances where a court has a discretion to allow it in. This is not earth-shattering or groundbreaking if Your Honor lets it in terms of it happens under certain circumstances. The circumstances being such as the case law and the issues that Your Honor is weighing. But in terms of whether it's the attorney-client privilege or it's the right for unreasonable searches and seizures, at the heart of it is the court being the gatekeeper. Both are governmental action. It's no different, because the ultimate thing that can be helpful to the prosecution of a case or hurtful in terms of evidence against the defense is if that evidence comes into court. So both are evidentiary issues. They're not these different things. The end result is the same. The state is acting. The state is trying to get both evidence in, whether the question is suppression for an illegal search and seizure or suppression because of a legitimate attorney-client privilege protected statement, which I've mentioned many reasons why it's not. So the end result is the same. The court has to determine, should it be admissible or should it not? Was it an unreasonable search and seizure? Was it legitimately an attorney-client privilege? And based upon the case law and the inquiry about should the defendant have known or reasonably known that his mom was going to see it, and was the statement when he made, was he thinking it was attorney-client privilege? Obviously, he could simply walk outside and take one of his walks that he so much loved to do, make a phone call, and we wouldn't be here. When he made that statement too, he wasn't thinking about it being protected or it not being protected. He was just saying it. So at the risk of repeating everything I've been saying, I have nothing else to say.
All right. Anything else, Ms. Thornhill?
No, sir, I
All right.
think you understand our position.
I think the difference lies in the fact that the law has said a parent can consent to the search of a bedroom of a child, and the child has no exclusionary claim under the Fourth Amendment for not consenting himself. When we're talking about the attorney-client privilege, I have not seen a case, and you have not presented one to me, that says point blank a parent can give up a child's attorney-client communications to law enforcement. And that right has always been personal to the client. And until and unless the court decides otherwise, that it's personal to the individual, I don't think this case is analogous. And finding that a parent's absolute right to surveil their child serves as a tool for their responsibility to act in the best interest of the child, in this case, and under these circumstances, means that when it is just the parent who the child might have reason to believe will see what's in the phone, there could be circumstances where this wouldn't apply. If he knows that he's sharing communications in an environment that others are going to be aware of, that don't have a duty to protect him, that's a different story. But even when a child's interests, legal interests, a child in legal jeopardy, even when those interests are contrary to the parent's personal interests, that doesn't vitiate the parent's duty to act in that child's best interest. And I think we see that in court downstairs in dependency when the parent is the victim of a domestic violence incident, for instance, in juvenile court. The parent still has a duty under those circumstances. It doesn't vitiate that responsibility. So that being said, I do not find that in this case, even though Mr. Griffith knew or should have known his mom was going to look through his phone, that in and of itself, with respect to her and her alone, in any way would have waived the confidential nature of the communication. Again, finding that the state, while the actual communication itself was unusual, eerie, it was also apparently in the context of some discussion about self-defense, and there were no other facts elicited at the hearing, no other context provided where I could say that the crime fraud exception applies. So in that respect, I am going to exclude it.
Judge, if I could inquire, and of course I respect the court's ruling, could I just inquire, is it also your finding that when the defendant made that text to Jeffrey Rapkin, that he intended at the time he made it, that it be privileged and a confidential attorney-client privilege, as opposed to now he wants to keep it out because it's going to hurt him?
Mr. Levine, you've asked, you keep saying a person has to say in their head, oh, I'm typing this message. It is attorney-client privilege. I don't think that's the thought process someone has to go through. I think the thought process is, I'm sending this to my lawyer, and my lawyer alone. I'm not sharing it with anyone, and especially when we're talking about a child, that the law should not require that child to even understand that the attorney-client privilege exists, per se, word for word. I mean, the child's right to confidential communications with their lawyer, when the communication itself indicates that it's about seeking advice from a lawyer, especially in this context when Mr. Griffith was currently accused of a crime. That burden should not be placed on a child to have to make that mental connection. And I'm not even certain anyone goes through that particular process in their mind when they're talking with their lawyer. So I'm not going to answer your question because I don't think it's necessary under the
All right, thank you.
circumstances. All right. Anything else we need to take up before the jury comes in?
Can I make a call downstairs to tell my assistant that Jeffrey Rapkin will not be needed for these proceedings? He was waiting on standby should the court rule that it was a miss.
Yes.
Thank you.
And I have no objection to him being released.
All right.
So far, from what I can see, this case is on the docket through February 4th. I wasn't sure how long this trial would last. I don't know if any of you guys are familiar, but I am following uh, the Suzanne Simpson case with Brad Simpson and Cotter, his business associate. There's some more cases, but if there's any cases that you are following, please share in the comments. I'm willing to go check them out. I like to dig into the documents and do some research and see, what they're all about. This one, which gravitated me, was more, I would have to say, the mental illness and how this all plays out, because my perspective from what I've seen and read, this was a horrible situation even before Collin did this, as far back as Oklahoma. Like, I got the impression that his dad just, I don't want to speak ill will of the dead because they cannot, defend themselves. But I was reading in some of the documents out of Oklahoma, in the transcripts here in Florida, that his dad had put cigarette burns. This is alleged, okay, because this is a neighbor or a friend, I couldn't remember. Collin had cigarette burns all up and down his back, and he was kept in a cage in the backyard. Now, whether that's true or not, because they did talk yesterday that Collin had his shirt off, and so there's been no mention of that. So I don't know. I just think you have a couple that has been married at a very young age. And I think, my personal opinion so far, they all have some mental issues. But regardless, I know his mom tried to get help. His dad refused it in documents I've seen for him to get any kind of medical in any sort of way, not just mental. And so, I don't know. This one just really puts chills up my spine. How, I guess, I even kind of, in a way, blame Florida a little bit on how this went on so long with all the phone calls. Even his own attorney. I would love to know what you guys think. It's still early. I can't speak. I haven't had enough coffee yet.
All right, are we ready for the jury?
Yes, sir.
All right,
Yes,
for
sir.
the record,
Before that, Your Honor.
for the record, Mr. Griffith is present with both lawyers, Mr. Levine.
I prepared a stipulation that I shared with the defense. If it still makes their approval, I would request that you read both 1 and 2 when the jury comes back into the courtroom, Your Honor.
All right, Mr. Griffith, listen carefully. I've been provided a document entitled Stipulations, and it reads, when parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. This is something that I would be reading to the jury. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are: 1, Catherine Griffith is dead, and 2, John Robida, Senior Crime Laboratory Analyst in the Biology Section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Parent, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your
All
Honor.
right. Have you discussed, you can put your hand down, have you discussed this stipulation with your lawyers?
Not in detail, Judge.
No, Your Honor.
Do you want to? Because I'm going to tell you one of these stipulations is an element of first-degree murder and the lesser included offenses of first-degree murder that the state would have to prove beyond a reasonable doubt with evidence absent this stipulation. So that's an important thing that I think you should discuss with your lawyers before you stipulate to it. They may have very good reasons as to why they think it's a good idea, but you need to know why they think it's a good idea. The other things are evidentiary matters that could have some impact on the state's proof in this case, affirmative proof in this case, and perhaps any defense that you might have in this case. So I think you should talk to your lawyers about this for a few minutes.
Yep.
But yes, I was shaking my head no to.
And
Jeff.
can you tell him, can you take, well, how long do you think you need?
A few minutes.
All right. We just need a couple minutes. He needs to go back there and talk with his lawyers. All right.
So I pulled up stipulated facts trial, and it's where the parties involved agreed on certain facts, which are then considered to be conclusively established. The parties involved in the trial can use stipulated facts as evidence against each other. Let me see something here. The parties involved agree on the facts in open court in the presence of the defendant. The defendant's attorney agrees to the stipulation. The stipulation is entered into the record. The jury must accept, so the judge spoke about that. And then why are stipulated facts trials used? Stipulated fact trials can save time and money for the parties involved. They can simply simplify the trial process by allowing the parties to focus on the issues that are still in dispute. This will be interesting. Let's see what Collin decides to do.
Mr. Griffith, did you just have a discussion with your lawyers about this stipulation?
I did, Your Honor.
Did they explain to you what the purpose of agreeing to that stipulation was?
Yes, Your
And did they give you some advice on what they thought about stipulating to it and why you should stipulate to it?
Yes, Your Honor.
Did they answer any questions you had about it?
Yes, Your Honor.
Addressed all your concerns?
Yes, Your Honor.
And do you agree with their proposal to stipulate to these particular facts?
Yes, Your Honor.
All right. And you understand the pros and cons of stipulating to those facts?
I do.
All right. Do you have any questions of me about the stipulation?
No, Your Honor.
And has anyone promised you anything or threatened you to get you to stipulate to these facts?
No, Your Honor.
Including your lawyers?
No, Your Honor.
And you're not currently under the influence of anything, are you?
No, Your Honor.
No medications today, correct?
No, Your Honor.
All right. And you're satisfied with the advice and counsel you've received from your lawyers on whether or not you should stipulate to these facts?
I am, Your Honor.
And you understand the jury will be told, these facts are proven beyond a reasonable doubt, essentially. They don't need any other proof of those facts, and they must accept these facts as true. You understand that?
I do, Your Honor.
And of course, it's for them to decide what to do with those facts and how significant they are. But I will be telling them they have to consider it. You understand that?
Yes, Your Honor.
All right. Anything else you want on the record?
No, sir.
No, Your Honor.
All right. I find that your choice to enter into this stipulation is freely, knowingly, and intelligently made upon the advice of competent counsel. You want me to read this first thing, Mr. Levine?
Yes, please, Your Honor.
All right.
And then Dr. Garavan will be the first witness of the morning.
All right.
I'm wondering if they're going to bring lead detective Danny Peters from Polk County. He was the lead detective. I'm wondering if they're going to conclude with him or they're going to bounce around. So I'm not sure how that's going to work just yet.
seated. Good morning, ladies and gentlemen. Welcome back. Thank you for your service. I want to apologize for the delay. I assure you we have all been here at the appointed time working to resolve a legal issue that has arisen in this case. That has been resolved, and we are ready to proceed. I want to advise you that when parties and lawyers agree that certain facts are true, that is called a stipulation of fact. Now, you must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts you must accept as true are as follows. 1. Catherine Griffith is dead. 2. John Robida, Senior Crime Laboratory Analyst, and let me stop you for a moment. I see you writing furiously. This is going to become part of your final instructions, and you will receive a written version of these instructions, and this will be in there word for word. 2. John Robida, Senior Crime Laboratory Analyst in the Biology Section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Mr. Levine?
Thank you, Your Honor. The state calls Dr. Garavan. Dr. Garavan.
Sergeant Clinton, raise your right hand, the clerk has ordered.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the truth, and nothing but the truth?
I do.
Good morning.
Good morning.
Mr. Levine.
Good morning, Dr. Garavan. May you please introduce yourself to the jury and spell your name for the record?
My full name is Dr. David Fintan, Fintan, Garavan, G for golf, A, V for Victor, AN.
Tell the jury about your profession.
So I'm currently working in District 10, which is this area, as a medical examiner. A medical examiner is a forensic pathologist. My qualifications start back. I completed my PhD in medical toxicology in 1994 in Trinity College, Dublin, Ireland. I completed medical school in Trinity College, Dublin, Ireland in 1999. I completed mandatory internal medicine and surgical rotations, which is required by our country, before entering into a pathology training program as a specialty, which was 5 years. I completed that in 2006. I started my fellowship in forensic pathology in Miami in 2006. I came here for 1 year, that was 17 years ago. I completed 3 years in different specialties within forensics in Miami, including cardiac, neuropathology and pediatric. I worked in Liverpool, England for 2 years as a forensic pathologist. I took my professional examinations in the Royal College of London in forensic pathology 2010. I then worked in New Zealand and the Pacific Islands for 5 years, travelling around the large country of New Zealand, but I was based in Auckland as a forensic pathologist. I returned to Miami in 2015 as a forensic pathologist. I was there for another 6 or 7 years. I was the deputy chief there for a period, and then I came to Polk County in 3 years ago, I think next month, where I'm working as a forensic pathologist. My other specialties are drugs or toxicology, in addition to forensic pathology.
Doctor, what does forensic pathology deal with?
So there are two types of pathologists. So if you have a lump or a bump or some part that needs to come off you, a biopsy or surgery, that will go to a pathologist, a surgical pathologist, and they will look at that under a microscope and make a tissue diagnosis, which will determine what treatment you have to, if any, that you will have to undergo after. A forensic pathologist will have done that, but we then move on to additional training where we're not looking at parts or biopsies, we're looking at the whole body, and our interest is to determine the cause of death, keeping in mind how natural disease or illnesses affect the human body, how that may cause death or impair the human body, how injuries affect the human body, either on their own or in combination with injury that may cause death or to a person, or drugs, the scene, depending on the environment where the body is found, and then the circumstances to a case, whether or not the person was involved in an altercation or not, or whether they were doing drugs or not, or a bit of both, or they were drinking, or they have some disease or illness that may have participated in the injury, the drinking, the drugs, that may provide an explanation to the police. Our purpose is to help police, our jury, or families to understand how somebody has died, or the mechanism, or what were the factors involved. We, in addition to determining the cause of death, we will determine the manner of death. The manner of death is the context within which the death has occurred. It can be natural, accident, suicide, homicide, or undetermined.
What is the definition of a homicide?
From our point of view, the medical point of view is different from a legal point of view. We do not make legal decisions. Our determinations are not the law. The law is a separate matter. But under the medical determination of homicide, it means that death has occurred as a result of a violation of some other action. So somebody has done something or made an action, or have made a series of decisions in an action which have resulted in the death of somebody else. That their action, any reasonable person would know or should have known that action could or should cause the death of another. So homicide is the death result of the actions of another.
Dr. Garavan, as a medical examiner, what are some of your responsibilities here in the 10th Judicial Circuit?
Similar to any other jurisdiction that I work, so our job as medical examiners here, so there are no coroners in Florida. Florida is one of the progressive states. We deal with just medical examiners who are highly trained professional medical doctors who review or are involved in making the decisions if someone needs to undergo an autopsy or not. It is not a decision taken lightly. There's a lot of work done before that decision is made. Autopsies, they're a lot of work. It's not something we do lightly. So there are many ways to do it. We may be contacted by police, we may be contacted by a hospital, we may be contacted by family members, because a death has occurred. By law, all deaths will be referred to us, but the vast majority will not fall under our jurisdiction. They are natural deaths. Somebody has died peacefully at home. It's not unexpected. They're of older age, or they had some condition which is understood that would or could lead to their death. Police have no suspicions, families have no concerns, and that's maybe 95%, 90% of deaths will go down that route. In the other percentage of cases, there's some issue. The death is unexpected. The death was unwitnessed, and there's no particularly obvious reason why they would have died in that moment, in that location. Police may have concerns that the person may have been involved in some incident, altercation, interaction in the days, hours prior to the death, and are wondering if there's some connection. If there's a belief that perhaps some drug or drugs may have been involved, that will fall under our jurisdiction. So if there's issues, particularly legal outstanding issues or concerns from a family, doesn't always mean that somebody has done something bad. It just means that there's an unanswered question And if we feel that an autopsy would be helpful in answering that question, we will take jurisdiction of the case, and then we will perform. So that's background information first of all. Once we decide we're going to do the autopsy, then there's this broken into several parts. The information review is no different than if you go to your doctor and they have a chart and they have all your medical information in it. They review that information before they examine you. We do exactly the same thing, it's just that you're deceased. So we'll get all that information. I can't ask you questions, but your body can tell me what's been going on. So we'll do an external examination first of all. The external examination will involve looking at you from top to toe, looking for evidence of natural disease or injuries or some clue to tell us that something happened in the environment. It might be electrical burn marks, there could be evidence of drowning, something like that. Then we'll move to the internal examination, where we examine all organs, all major systems, brain, nervous tissue, heart, lungs, and so on. We may choose to take biopsies of all of those tissues to look under the microscope for the presence of natural disease that might provide an explanation as to what's happened. We will take samples for toxicology or biochemistry or microbiology, depending on what's more appropriate for each case, and send them off for testing. When we have all that information back, and it often takes weeks, nothing got to do with us, it just takes weeks for laboratories to do what they have to do. We will then pull all that information together, taking into account the narrative, the scene, medical examination, the various results. We will then form an opinion as to what was the cause of death and under what context that death took place. So each case takes many hours, and I would do approximately 300 cases a year, autopsies, and I will do external examinations only on probably another 200, and I will review another 600 or 700 that I would decide that I'm not doing anything with. So that's how many cases we would be constantly dealing with.
The external examination of a deceased individual sounds pretty obvious, but how do you do the internal examination?
The internal examination it's an intrusive procedure, and we're aware of that. That's why we don't make the decision lightly. It requires that we have to open the body. You have to open the chest, the abdomen, the head, look into the pelvis, which is part of the abdomen examination. And if we need to do, there are many other specialist tests that we can do if we need to, which would require further intrusive methods, but they're done with as much skill as we can, so that when the bodies are returned to the families, that all of that's hidden. That's out of view. We try to close it up so that you wouldn't know the difference. But it is a very involved procedure. It's manual, it's not easy work, and it's tiring.
Now, in the normal course of an autopsy, are photographs taken of the deceased victim both internally and externally?
Yes.
And in this particular case, I'm going to have the opportunity to show you State Exhibits 125 to 155 a little bit later. Will that be helpful for you to be able to point out and explain some of the injuries and some of your findings that Kathy Griffith suffered?
Yes.
Now, in this particular case, the death happened on a Sunday, September 8th. Describe to the jury the process by which you receive the body and when you typically conduct an autopsy.
So the only reason why this case is with me is because that was my week. There's no other reason. We work on rotations. So I would have first met this case on Monday morning. I would not necessarily have heard about it on the Sunday. I don't remember, to be honest with you. I just don't. So when I went in on Monday morning, her name plus other names were on that list that morning, and that's the first time I would get to read the police report to find out that's the beginning of the narrative. In all homicide cases, police do attend those cases, the investigating detectives, which is very useful because then I can have a much more one-to-one conversation. So that's where I would have got my information.
Do you work for the State Attorney's Office? Do you work for me?
I do not.
Do you work for law enforcement?
I do not.
Who do you work for?
I work for the public.
All right, Dr. Garvin, the autopsy that you performed on Catherine Griffith, describe to the jury a little bit about the room or operating location where you do your autopsy.
So our autopsy suite is it's a custom built place. It's got 2 stations where we can conduct our examinations. We tend to use one. It's an open. It's no different from an operating area. We don't have to have the high clean room specifications of an operating theatre, but it's no different. There's a table and there's ventilation and there's instruments and they're all laid out and so on and so forth. So it would look quite similar to an operating table.
Now, before we get to the cause of death and the manner of death towards the end of your testimony, I want to ask you about your autopsy findings. What can you tell the jury about the injuries that Kathy Griffith suffered?
Do you want me to go through all of them in detail or just a summary?
First, we can start with a summary.
So the autopsy findings, a sharp force injury to the right side of the neck, bruising to her lower limbs, bruising to the posterior right shoulder, left elbow, back of both hands. There was an incised wound, and I'm going to explain the difference between an incised wound and a stab wound in a second, between her thumb and index finger of the right hand. So here there's an incised wound that was 1.5 centimeters. It was gaping if you open the hand, so 1 centimeter. A stab wound is a wound that is deeper than it is longer on the surface. An incised wound is a sharp force injury as well, that's longer on the surface than it is deeper. They're the opposite. So in an incised wound, the sharp blade or the sharp surface has come across the skin, but has not gone deep into it. A stab wound is the opposite. It's penetrated and gone into the actual tissue.
Was that gaping incised wound, was that a fresh wound?
Yes.
And describe to the jury why that is.
Because it's there's no evidence of healing. It's gaping, it's opened, and it had dry blood in it.
Now, is that gaping incised wound consistent with being a defensive wound?
It's possible that, defensive wounds are, so that's a term that's used, and I know it's thrown around a lot. We personally don't write down classic for defensive wound because we don't know precisely what the circumstances of it happened. But let me explain what the greater points of a defensive wound are. Defensive wounds is a term that's used when there's a series of injuries that can be bruises, can be incised wounds, it can be any other cuts or abrasions that are present on certain locations. And the reason why there's certain locations is that you have to understand that fundamentally the human will or the human body is designed to survive. Everything about us when we're under attack, when we're in a fight or flight situation, regardless of the circumstance, that if the human person is conscious enough to understand that they're in a struggle for their life for whatever reason, they will engage in activities which will try to help them survive. If you're under attack from an assailant, it is quite typical if the person is swinging something at you, baseball bat, fist, whatever, you will tend to try and protect yourself. And in doing so, certain parts of your body become exposed to that force that's coming at you as you try to defend yourself. In the arms is typically here. If it's a bat or a stick or something that's coming at you. They may also be on the legs. Typically, if and it's more common in women if they're being attacked, but it happens in men too. They will tend to offer the outside of the leg as they're trying to protect their sexual organs or they're trying to protect themselves if they're under attack. So we will often find wounds on the outside of the legs, not the inside. In knife injuries, when someone is under attack where there's a knife or a sharp implement involved, it's common that the person, unfortunately, mistakenly, will try to grab that knife thinking that this is somehow going to be of help to them. It isn't really, generally, but in doing so, if they grab that blade and then that blade is pulled, you'll often find incised wounds across the palm of the hand, or it can be here, depending on how the knife is grabbed. Or it could very well be that as the hand goes up to defend against the oncoming blade, that that blade just comes through here and then cuts as it comes through. Because I don't know specifically, we don't have a video of how exactly those injuries occurred. We tend not to use that term, defensive injuries, but that is what's meant by them. They're present in certain locations under certain circumstances that may indicate that the person who is now deceased was trying to defend themselves at the time of the assault.
Now, you mentioned that Kathy had bruises on her upper and lower limbs. Does that mean arms and legs?
Yeah, so again, I know it seems a bit impersonal, but we say the lower limbs and the upper limbs because we're talking about the whole arm. When we want to talk more specifically, we tend to use the anatomical location, whether or not it's the anterior elbow or the posterior forearm or whatever it might be. But upper limb is the entire limb from here to the fingers.
What were you able to determine about the bruises on Kathy regarding whether they were old bruises or new bruises or a combination?
Yeah, so dating of bruises is not it's not an exact science. We do not, TV shows I know do that all the time. That's not reality. What I can say is that these bruises, there were quite a number of them present. All we can say about bruises is that if the color yellow is present, we can say that it's definitely not, there wasn't an immediate before death bruise, because yellow would suggest that at least 15, 16, 17 hours has passed since that bruise was present. It could be weeks, but at least 17 or 18 hours has passed. That's the best we can do in reality. But all these bruises in this particular case did look fresh in that there was no color change. It doesn't look like they had gone or had the opportunity. The person wasn't alive long enough for the body to try and heal or start healing a bruise. So that's the best I can say to you.
Dr. Garrigan, before we get to the photographs, how can you describe Kathy's neck wound to the right side of her neck?
So the wound on the right side of the neck is a large stab wound. It's gaping, and gaping means that it's an obvious. Once you see it, it can't be anything else. It's an open wound. It was 4.3 centimeters long and 1 centimeter apart. It's 2.5 centimeters right off the midline, so approximately here, and 23 centimeters from the top of her head. So we do that just to give you an anatomical location. So approximately here on her neck is where it was. The wound is in the 9 to 3 o'clock orientation, meaning that if you look at a clock, 9 to 3 means it's kind of looking straight when the body's in the right, so it's coming straight across here. And there's a square edge to the 9 o'clock margin. That's important because the square edge suggests to me that it's a single blade, not a double blade. That is the knife or the blade that's been used to cause. So there are characteristics of a knife wound which help us determine if it's a single blade or a double blade. And in this case, it would suggest the blade was single bladed. So the wound then goes into the neck. It travels from a front to back, so it's coming in from the front and heading towards the back. It's traveling right to left, and in doing so, and it has gone through. So the esophagus, the food pipe, has gone through the trachea, the windpipe, and it's just above the vocal cord. So it's transected the trachea right across, and the food pipe. And the blade continues so that the top of the blade came out the other side. So there's a small sharp force injury on this side. It's 0.6 by 0.2, so quite small, but it shows that the tip of the blade met it all the way across and poked out this side.
What type of force is necessary for the knife not to just enter the body, but to do all that traveling that you mentioned and actually go out the other side of her neck?
We often get asked this question. In fact, we always get asked this question: how much force is required? We don't know, right? We don't have the ability to be there to measure Newton's pounds per square inch or whatever. But what we can tell you is that one of the major qualities, the most influential quality of how easy a knife will penetrate the human body is the tip of the knife. The tip of the knife, once it punctures or penetrates the human skin, it's relatively easy for the knife to then enter, because our organs and our tissue they don't offer much resistance. So I can't tell you how much force was used, but I can tell you it can be surprisingly not as much required as you might think. However, in this case, it's gone through the trachea. The trachea is a tougher organ or tissue. It's got cartilage in it, so it would require the application of some pressure for it to continue to the other side. But I can't tell you in pounds per square inch how much that pressure is.
Now, have you had the opportunity to conduct autopsies on multiple stab wound victims over your years?
I've done many hundreds.
And do you see any consistencies amongst those in terms of the nature of the injury or the cause of the injury?
Well, I've seen all kinds, homicides, I've seen suicides. I don't believe I've come across any accidents, but I've seen suicides. Certainly people have used knives to take their own life, but the vast majority would be homicides.
All right, so the vast majority are homicides. You've seen some suicides, but no accidents, correct?
Not to my knowledge, no.
All right, Dr. Garvan, I'm going to show you some photographs, and hopefully it shows up on your screen. And if I have some questions about them, of course, I'll be asking you some questions. So, starting with 126, is this how the body comes to you?
Yes.
127, 128. During your autopsy, were you able to determine the victim's weight and height?
Yes.
What were those stats?
She was 5'2" and 126 pounds.
Is that a picture of the stab wound?
Yes, as the body arrived before it's cleaned, yes. That's the same wound after it's been cleaned.
Now you mentioned gaping wound and the definition being wide open. What is it that we're actually seeing once you get past into the hole there?
You're looking at the internal structures of the neck. So the head is back, so it obviously pulls on it to make it gape more, but there are other reasons. It's a lot more details to it. So there are things called the lines of Langerhans. When you're all young and pretty, of course, you won't know about these lines of Langerhans because your skin is nice and tight and there's no wrinkles. But as we get older, the lines of Langerhans begin to take over, and they are a natural tension line that's present in all our skin. And if we cut across the lines of Langerhans, you may be familiar with the grain of meat, then the wound are gaping. But if we cut in the same direction of the lines, which surgeons will always try and do, because then the scar will be a lot less obvious. In the neck, they are roughly coming down the neck in a straight line, so this wound has gone across them. So those lines are now apart, and that makes it gape more than if the wound was the other direction, between 12 and 6.
So in this picture,
I would like for you to know, if you need it, that mouse over there operates as a pointer.
Oh, yeah, thank you. Actually, I didn't know that, but thank you.
could you please point with the mouse and the red arrow? Where's the visible organ within her neck?
So in here, you can see that there's a structure present here. This is probably part of the larynx, probably part of it, but clearly it's a gaping wound, and you can see that there is a structure inside here. I think it's part of the larynx from looking straight in, but I'm not entirely sure. That's part of where the voice box or the larynx has been transected, so it's cut open. That should be a whole piece. It shouldn't be separated like that.
Now, in order for the end result to be the death, what happens physiologically after that knife does all that damage?
Yeah, there's a couple of things. So the neck, the human neck is extremely vulnerable. It's probably the most vulnerable part of our body. So once a knife goes in, not only are there your windpipe, your food pipe, there's also a lot of arteries which conduct a lot of blood, but there are also several nerves that are traveling through the neck, the vagus nerve, the phrenic nerve, and so on, and they're coming down. If you transect them, there's immediate implications, clearly. The vagus nerve supplies the heart, and the phrenic nerve supplies the diaphragm to which you need to breathe. It has to have that bellow effect. So if they're transected, then they're not available to you anymore. So you have a combination of bleeding and severing of nerves combined will bring a rapid death.
Is the bleeding both external and internal?
I would expect this to be a bloody scene, yes.
(132). Is there any different parts of the organ visible in this picture?
No.
All right, now we continue 133. What's that there?
So that's the exit of the tip of the knife. So the tip of the knife has come all the way across the neck and has poked out here.
Is that a close-up of the exit wound?
Yes.
Now, there's a metal rod there. Describe to us what you were doing here.
So in all gunshot wounds and in stab wounds where possible, we will put in probes to show the direction that the wound is traveling in. So in this case, it's traveling right to left, upwards, front to back, and that probe is following the path, the same path that the knife followed.
What can you tell us about 137, Dr. Garvin?
So this is the internal examination. I've taken out the neck structures. You are looking at the neck from behind. So here is the epiglottis. This is the tongue, and this is the esophagus that's open, and the trachea is underneath. It will be this is the epiglottis. This is the posterior surface of the larynx, and here the blade has gone through the upper part of the esophagus, as I'm pointing out there. So this fold and this fold connect. So this would be a tube. The lumen here is your food pipe. I've opened it to show you that the blade travelled through the esophagus, which is transected the esophagus, or perforated, I should say, the esophagus.
138. What do we begin to see here?
So this is the right hand, and you can see there's a bruise here, and it's not well shown in this picture, but this is where the incised wound between the thumb and the index finger is. There's some bruising down here also at the bottom. This is the index, this is the thumb and the index finger of the right hand, and this is that incised wound that I talked about. So it is longer on the surface than it is penetrating. And it's from a sharp force injury, I suspect, from a blade.
Going back to, you mentioned the bruising. So due to the color of that bruising, does that coincide with what you were saying are more fresh bruises on Kathy?
Yeah, these do not look as if they have had time to heal or undergo the healing process.
All right, what can you tell us about 141, Doctor?
This is her left upper arm, and there's some bruising here, there's some bruising on the elbows. These are abrasions, but they are not injuries. These are post-mortem. There are differences. They happen after death, and it's got to do with many other things, but they're commonly often misinterpreted as injuries. They are not, due to their yellow, parchment-like colour. And I can appreciate if you don't see it, but there are actually small veins running through the bottom there, and that's quintessential of post-mortem, not an injury. But there are injuries, and the injuries are here, the elbow, and up here on the, just at the biceps and down here.
Continue on with the close-up, and we continue with some additional photos. Now we have 143. What appears to be on the wrist area and the hand?
Yeah, so this is the left, it looks like the left upper arm, so there's that bicep bruise, and this is, you know, heavy enough bruising present on the posterior wrist and hand. Some small bruising here also.
Is that another view of it, different angle?
Yeah, and there's also just another bruise there on the back of the little finger. That's the left hand also, and the left arm, and there's some bruising here.
Can bruising be caused by if somebody grabs somebody real tightly?
Bruises, by definition, I mean, it's better to just go with the definition, and then you can work it out thereafter. So in our forensic pathology, a bruise is where blood has escaped into the soft tissue due to blunt force trauma, not due to a sharp force injury, not due to a bullet wound. It's due to blunt force trauma. What the blunt force trauma is can be a whole range of things. It could be grabbing, it could be punching, it could be falling, it could be kicking, but it's blunt force trauma.
All right, thank you, Doctor. What do we see here?
This is the other arm, that's the right arm, and there's a bruise across the triceps here. Right elbow, more bruising. Back of the right hand. I think that's the right hand, it is, yeah. And there's some bruising there on the back of it. And up here on the back of the index finger of the right hand. That's a small abrasion, minor abrasion on the right shin by the look, yes, the right shin. You can see bruising here at the back of the left, this is the left calf. There's some bruising here on the anterior shin, here, here, here. This is an abrasion along here. So an abrasion is just for your definition. So a bruising is the loss of, is the escape of blood into surrounding tissue. An abrasion is due to blunt force trauma, but is confined to the epidermis. So the outer layer of skin is the epidermis. So as something rubs across that for whatever reason, blunt force comes across the skin and pulls or rips or tears that epidermis, that's an abrasion. Okay, and they're only due to blunt force trauma typically.
And the last few photographs, Doctor.
This is an abrasion, but I suspect that's post-mortem. I would not probably call that an injury. That's an injury. That's an abrasion. That's a skipped-like abrasion, incomplete abrasion. So something, whatever has caused this, either it has skipped along the skin or it itself was not fully in contact with the skin as it was rubbed across the skin, causing the abrasion. Bruising is present on the forearm, here and here.
Now, from your conducting the autopsy and your training and experience, what was the cause of death?
So the cause of death is stab wound of the right neck.
And what was the manner of death?
In this case, the manner of death is homicide.
And when you say the manner of death is homicide, what does that mean?
So with the information that would have been provided to me at the time, and with the examination and what I've viewed and witnessed and reviewed, the explanation for this death is that this wound was inflicted by another person.
So is it a fair statement that it is not consistent with somebody accidentally falling on a knife?
I haven't been given that explanation before, but I think that would be rather extraordinary. No, I don't believe so.
So your end result was that this was the manner of death was a homicide, a killing caused by somebody else, correct?
Correct. Yeah.
All right, Dr. Garavan, I have no further questions.
Thank you.
Ross?
Good morning, Doctor.
Morning.
Dr. Garavan, I want to talk about injuries that can result from mutual combat or a fight where two people are mutually involved in a struggle, whatever. They can be very messy, correct?
Well, I suppose mutual combat, mortal combat could very well be messy depending on the circumstance, yes.
Well, if any two people, regardless of size, strength, etc., are involved in a fight, both can receive injuries, correct?
Yes.
And both can receive what you termed defensive wounds, even though that's not a term of art, it's sort of a vague term. But
Yes.
you would agree that both could receive those types of wounds?
Yes.
And you would agree that both could also suffer offensive wounds in such mutual combat?
Yes.
And even if somebody suffers a wound that ends up leading to their death, you don't know from your evaluation what happened leading up to that wound, correct?
So depending on the information provided by police, so I am given some information, but it depends in each case. Sometimes we know nothing, but in this case I knew something.
Right, and then the information that you get from police is their interpretation of things, correct?
Yeah, I rely upon them. I'm that's how it works. I rely on the information they give me. Yes, that's correct.
And so if they don't give you all of the information that they have, then you might be lacking some critical piece of information in making your determination.
I'd be very disappointed if that happened, but yes, you are technically correct if I'm not given all the information.
Do you also look at media accounts of what allegedly occurred?
I
that
do
led to
not
the death?
watch the news. I have no media. I have no social media. God, no. I have better things to do with my time.
So this is a weird question then. Why does the medical examiner's file in this case contain multiple media reports?
The secretaries in the office will do that as part of the thing, but I only saw them yesterday for the first time, and I don't read them. But it's common practice around the world. I've been in other offices. People do that, but it's nothing got to do with me.
Okay, just checking.
Yeah.
But basically, you cannot say what happened in the kitchen where Catherine Griffith suffered this wound, can you?
Well, I can certainly say that she suffered a fatal stab wound or has suffered fatal injuries, and based on the information provided to me at the time, that the most likely determination, excuse me, is that she's died from the action of another person, therefore a homicide.
But you can't say, for example, whether Catherine Griffith attacked the other person with a knife first, right?
No.
Okay. And you don't know how everybody was positioned or whether there was a struggle over the knife or anything like that?
Not in this case. Sometimes we do, but not in this case. I did not have that detail of information.
Speaking about the bruises that you've shown the jury, those could be up to several days old, couldn't they?
So dating of bruises is tricky. There's no argument there. But in this case, I wouldn't say days, but could they have been present a couple of hours before the incident? I can't tell you.
Okay. And bruises such as we saw on the photos could happen from somebody bumping into something?
Yeah, absolutely. I mean, people can bruise very easily. You always get a bit concerned when there's a lot of them, and there are a lot of them. And I wasn't provided with an explanation other than a confrontation that might provide an explanation for them.
What about from doing innocuous activities like housework or things like that?
Also, yeah, it's entirely possible, and again, you would take that into account if it's as you are now, and that's perfectly fine. And yes, people can get bruises doing innocuous things. But the thing about innocuous things is that they tend to be very few bruises. They tend to be confined to one particular place depending on what they were doing. And in this case, there's a lot of bruises and they're in a lot of locations. So if you can give me the innocuous thing they were doing, I would consider it. But otherwise, for me, it more likely than not would be better explained being received during a confrontation.
A confrontation that could have been mutual combat.
Yeah, absolutely. A violent confrontation for whatever reason.
Do you, can you say whether somebody who has rheumatoid arthritis might bruise more easily than someone who doesn't?
It's not something I'm aware of as being a thing, but if they're taking if they're on a lot of steroids as part of the treatment, people on steroids do bruise easier.
Was there any way for you to determine whether Catherine Griffith was taking steroids for rheumatoid arthritis?
So wasn't aware that she was taking steroids, wasn't asked about that, and even if it was, to test for steroids is extraordinarily difficult. There are very few places in the world that do it, and even if you do it and you find steroid is present and you know she's taking it, well, I haven't proved anything. So if somebody tells me she's taking it, that's fine, but I wasn't told that.
Right, and I'm not suggesting that that's something that you normally would have been aware of, given the fact that the autopsy happened the day after she died and you spoke with law enforcement, not family members, right?
Correct.
Right. I'm just asking about that possibility.
Sure, yeah.
In your training and experience, have you ever observed bruises that are clearly made from, say, a hand or fingers?
Yes,
So if somebody's grabbing somebody's arm,
yes.
like I'm showing, so fingers around the arm, you would expect to see bruising that resembles the shape of the fingers.
It can do. They have a name. They're called discoid bruises, meaning looks like the pads of your finger. It can happen, and certainly I have seen them, particularly in young women that have died by strangulation. You can see, not in every case, but you can see the hallmarks of what looked like fingertips or somebody was grabbed by the neck by their fingers. It's also possible that if a person is strong enough and the other person is small enough, you can get similar discoid-like bruises. There's nothing about the bruise that screams at you, this is a fingertip. But what you can do is that if somebody says, could that be a fingertip? Then you can say, yes, that could be a fingertip.
Did you notice any of those types of bruises on Catherine Griffith?
Nothing that would have jumped out at me as specifically that. Yeah.
You've mentioned that the neck is a particularly vulnerable spot on the human body. There was no bone involved in this stab wound, was there?
It did not go through the cervical spine, no.
Okay, so it went through soft tissue, basically.
Soft tissue and trachea, which is cartilage. It's a
Cartilage.
little firmer, but yeah, it's not a whole lot, but it's a little firmer.
And so far as you know, there was no clothing or any object over the Catherine Griffith's neck to also provide, say, a layer of protection beyond her own skin.
I'm not aware if there was, yeah. I didn't see any or wasn't told about it.
You mentioned that the cartilage is a little bit tougher than some of the other soft tissue that the knife went through. And maybe this is crazy, but explain what a tracheotomy is.
So tracheotomy, you're talking about in emergency situations, I'm not trying to be facetious, but a cricoid tracheotomy, a cricoid tracheotomy. If you're in an emergency situation, the person's airway is compromised for whatever reason, a crushing injury or something is blocking the airway, and you need to get air into the airway, so you bypass the blockage. So you find the Adam's apple,
Which is the trachea, right?
which is the voice box. It's the front of the voice box, more prominent in males than females. But then you come down approximately 1 finger, but as you rub there, you feel a little dip. It's very subtle, but you'll feel it. And that's where you want to make your incision. But that's not going through cartilage, it's going through this soft tissue in between.
My mistake. You mentioned in your direct testimony that you can't say with any certainty what level of force was necessary to make this wound.
No, I can't give you a number. No.
And you said that the But you are aware that there are some variables that can give us some information about the level of force.
Yeah.
If you're looking at a spectrum from very little to a whole lot.
Yeah, there are, but from my point of view, it's the tip of the blade that really, once the tip of the blade overcomes the skin, the greatest resistance is from the skin.
Correct.
And once you get over that, you'd be surprised how little actually is involved. But that doesn't mean that the person wasn't using a lot of force. It just means I can't tell you.
Right, I understand. And in this particular case, the tip of the knife that that caused this wound was triangular in shape. Are you aware of that?
I don't believe the knife was shown to me. I wasn't brought the knife from memory, at least. Look, I've seen so many cases since in between. I might be missed, but I don't think. But I think I may have seen a photograph of the knife.
So what is it your understanding that it was a triangular tip?
Yeah, like a typical kitchen large carving knife, I guess is what I would call it. Yeah.
And would you agree that that type of tip is actually, geometrically speaking, is the easiest to penetrate the skin with?
Yeah, so that's a sharp tip, and that once it penetrates the skin, you don't anticipate much more force being required for it to continue in.
I want to ask you a question about the toxicology in this case. I know you personally did not perform the toxicology tests, but you received the results of the toxicology tests on Catherine Griffith's blood, right?
Yes, correct. We take the samples, they're sent to a toxicology laboratory. It's a whole different world. They live in a different place, but they're the ones who do the testing. It's up to us to do the interpretation.
Right, and in this particular case, while you didn't find that the toxicology results contributed to Catherine Griffith's death, there were some drugs in her system that you were at least concerned enough to note in your report, right?
Yeah, I wouldn't say I'd use the word concern. I'm kind of obligated to tell the truth, and if they're in the report, I've got to report that. I can't hide it. But there were 2 drugs present, that is correct.
Okay, what were the drugs?
One drug is called alprazolam, you might know it as Xanax, and the other drug is amphetamine.
Okay, tell the jury about alprazolam.
So I'm sure I'd be surprised if you haven't heard about Xanax. It's a drug which is given, is widely abused by many people, but it's a legitimate drug. It's prescribed. Typically, belong to a class of drugs similar to Valium. It's a benzodiazepine, and it's used typically for anxiety. People who are prone to anxiety or have anxiety. It can be used for other reasons, but that's the main reason. People who who have symptoms or signs of anxiety. There might be, heartbeat, racing heartbeat, chest palpitations, whatever the case may be, not sleeping well. Typically, Xanax can be prescribed for that.
As far as some of the side effects that could occur from alprazolam, do some of those side effects, although they might be rare, include racing thoughts?
Yeah, it's like any drug. No drug is perfect. Some drugs, they can have strange side effects. It's true. Can Xanax cause the opposite almost of what it's designed to do? Like any drug, that can happen. It would be very rare, but it can happen.
What about agitation? Can Xanax cause agitation?
And oddly enough, it's paradoxical. It's given for agitation, so why would it be causing that? In very rare cases, it's been known to happen.
And what about risk-taking behavior? Can it also cause that?
Risk-taking behavior. What do you mean by risk-taking behavior?
That's just what the literature said. That's the term I'm asking about. I mean, it can be interpreted many different ways.
Yeah, it can. Yeah, it is a drug. It is a drug that's commonly abused, I suppose. So if people are using it in an abusive manner, that's not the medical reason why they were taking it or the reason why they're prescribed it. So I'm not sure what risk-taking behavior is, but it can be abused or misused.
You have no idea whether Catherine Griffith had a valid prescription for Xanax.
I
you?
do not.
The amount that was in her blood could have been well above a therapeutic dose that a doctor would prescribe, correct?
Tricky one to answer,
Yes.
because Xanax is, like most other benzodiazepines, is a drug that's subject to what's called tolerance. What does that mean? Simply put, if any of you drink alcohol, you probably noticed that the first time you drank alcohol it had a certain effect on you, but as you continue to drink and get older, you seem to need more of the alcohol to get the same effect. That's tolerance. So you need more of the drug for it to do the same thing. Xanax is certainly prone to that. So looking at a blood level in a post-mortem setting doesn't tell you a lot about whether that person was taking too much or it's had an effect on them, or this could be her normal. This could be just the amount she needs to have to be on a steady keel. Maybe it was a lot higher in the day. This is just a snapshot of what we caught. There's also another reason to make it complicated for you. I mean, it does take a while to get through all of this. There's a thing called post-mortem redistribution, okay, and that is a circumstance where if you take a certain drug or certain drugs for long enough in your life, you would think that they go in, circulate around your blood, and then the body gets rid of them. Not true. Right? If you take certain drugs long enough, the body goes in, circulate around the blood, and then there's part of them are stored, sequestered, like a jury is sequestered in a room, and they're not available to the body, but they've dissolved into fatty tissues, or they've dissolved in other compartments of our body, which is water, fat, protein, and so on. And then after death, when you die, those stores are released and they go back into the blood. Some of them do. So sometimes the blood result you're looking at is actually higher than it would have been when she was alive, or anybody was alive. So it's another factor we have to take into account, and Xanax is one of those drugs. So depending on how long and how much she was taken, this 27 could be a little higher than what it would have been at the time of her death. But in any event, it is not at a level that would concern me that it participated in her death, that it would have impaired her beyond some extraordinary means. It's almost, if you're doing enough of these cases long enough, 27 is not high, and it wouldn't concern me personally.
Okay. But it could be above a therapeutic dose that a doctor prescribed to her.
Yeah, so again, for the same reason I've just explained,
Yep.
therapeutic, we can't use the terms therapeutic because we're not dealing with a therapeutic situation because it's post-mortem. And secondly, I don't know how much she's been prescribed or how
Or
much
if
she's
she's
taken.
been prescribed.
Or even if she is
Right.
being prescribed, correct. I don't know that.
Okay, so then let's go to the amphetamine. What is amphetamine?
So amphetamine is a stimulant drug. It's belonged to the amphetamine class. It's a subclass of another division of drugs called the phenylethylamines, of which that's an entirely large family. But the amphetamines have been around for quite a while, maybe late 1800s, early 1900s. They really became into their own in probably World War II, when the German army figured out that by giving them to the soldiers that they needed less food and they could stay awake longer because they were running out of men. So they needed the few men to have. So they were given, Hitler famously was partly, one of the many drugs he was taking was an amphetamine. So they've been around a long time.
So basically it's what some people refer to as speed or an upper.
It's an upper, it's a stimulant. It activates the nervous system to reduce tiredness or appetite and to stimulate the sensation of being awake.
Which is sort of the opposite of what a benzodiazepine or alprazolam is designed to do.
Yes.
Right? Okay. Amphetamines can cause side effects such as erratic behavior
Yes.
and sometimes even violence.
Any stimulant can be associated with violent behavior in certain people at certain times, yes.
And Catherine Griffith had both amphetamines and alprazolam in her blood.
Yep, the amphetamine is reported at less than 0.1 milligram per litre, which is about 100 nanograms per mil. It's a very, very low amount, but it's there.
Do you know if she had been prescribed amphetamines?
I do not know that.
I don't have any other questions.
Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Doctor, could you tell the jury about amphetamines being prescribed for like a legal prescription? What would be an example of that to treat what?
Yeah, so amphetamines are prescribed, can be prescribed. The more common one is ADHD. So typically, there are several formulas available on the commercial market. So that's one, and the other one that I know of is narcolepsy. People who suffer from sudden bouts of falling asleep can be prescribed amphetamine. So there are genuine, legitimate reasons why somebody may have it in their bloodstream.
The two substances in Captain Griffith's toxicology results, is it a fair statement they have nothing to do with their cause of death or manner of death?
I don't believe so, no.
All right, I have no further questions for you, Doctor.
Thank you.
Thank you. Is he released?
Yes, sir.
Ms. Thornhill?
Yes, sir.
Thank you,
Thank you,
Doctor.
Your Honor. Thank you. Thank you.
All right, ladies and gentlemen, it's just past 10:30. We'll go ahead and take our mid-morning recess of 15 minutes.
All rise, please. May be seated.
Thank you for the break, Mr. Levine.
Your Honor, I have, the next witness is going to be Robert Volantis. I have instructed him that he, pursuant to the court's ruling and order, that he is not to mention in any way, shape, or form that the defendant killed his dad. So that will not be elicited from me. He understands that. But in an abundance of caution, if perhaps Your Honor could instruct him outside the presence of the jury.
Mr. Levine, do you mean you're not even going to ask him about that incident at all, or he just needs to know he can't say it was the defendant's father or relative?
Well, if I remember correctly, Your Honor.
I don't know what you intend to present, is why I'm asking that.
Yes, if I remember correctly, and please correct me if I'm wrong, but I believe Your Honor ruled that he could not mention that the defendant told him that the killing in Oklahoma was not an accident, and that it was planned, even without mentioning that it was the defendant's dad that he killed. That's my understanding of your ruling. So that if that wasn't your ruling, then I would ask him that.
I think that was my ruling, but I didn't know what other
Correct.
information he might have that's adjacent to that.
Gotcha. No, I will not be asking him anything about the killing in Oklahoma, and he understands that. But once again, where we are in the trial, which is coming in the home stretch of the state's case, and to ensure the integrity of not getting a mistrial, I would request that you order him to not discuss that.
And I wholeheartedly agree with Mr. Levine's suggestion to speak with him outside the presence of the jury.
Let's do that when I get back, so it's as fresh in his mind before he's called to the stand.
Very good. Thank you, Your Honor.
Okay, they're going to do a 15-minute recess. They were discussing Robert Walantas. That is Catherine Griffith's father. I don't know if any of you guys know, but Catherine told her dad that Collin had admitted to her that he planned and killed his dad. So that's where we're at. I am going to go refill my coffee cup up. Uh, you guys go grab a beverage or a snack or whatever you need, and we'll see you guys, I'm going to say, in about 15 minutes. Hey, Mary, which lawyer are you referring to? Are you talking about Collins or are you talking about the state? I'm getting ready to switch over. Hang on. And you know what? I was going to tell you, Mary, please feel free, to speak openly. We're going to go into court now.
Swear or affirm that any testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
All right. You are Robert Willantis, correct?
Yes, Judge.
All right, Mr. Willantis, the parties have asked me to speak with you a moment to make sure you understand the limits of your testimony. Mr. Levine apparently has already discussed this with you, but I do not believe, and it's been represented to me, that neither party will be asking you anything about Charles Griffith's killing in Oklahoma. You understand that, correct?
Yes, Judge.
And that is correct, Mr. Levine. You are not going to ask.
I am not sure if it looks like it's on Long Crimes End. I'm going to try and see if I can figure out what is going on as far as no sound or video. 1 second. Okay, it's definitely Long Crimes. I'm sure they're going to rehook back up, so give it 1 moment.
Yes.
that if there is going to be a question such as, while Collin was living with his dad in Oklahoma, it sounds like the rest of that question might be, did Kathy have much contact with him? And the basis of that objection to that would be hearsay, because he doesn't know that. He would have been told that by Kathy. So, like I said, I'm guessing at what the second part of that possible question might be, but I'm worried
Mr.
that
Levine, is that where you were going?
No, Your Honor. My question will be something to the effect of, did the defendant live with his father in Oklahoma for a few years while Kathy remained in Florida?
All right. Thank you, sir. All right, we're ready for the jury.
All right, please.
You may be seated. Mr. Levine, state's next witness.
Your Honor, the state calls Robert Wolantis.
Step this way, please. Can you read your right hand?
Do you solemnly swear or affirm that the testimony given in this case will be the truth, the whole truth, and nothing but the truth?
Good morning, sir.
Good morning, Judge.
Mr. Levine.
Thank you, Your Honor. Good morning, Mr. Wolantis. May you please introduce yourself to the jury and spell your name for the record?
Good morning, ladies and gentlemen of the jury. My name is Robert Wolantis. Robert, R-O-B-E-R-T, Wolantis, W-A-L-A-N-T-A-S.
Looks like Long Crime's having a bunch of tech issues today. Hang in there. It'll be back. This isn't good. We're missing part of his testimony. Need to know stuff.
One 181 says Continental Divide.
It is. That's in eastern New Mexico.
And then,
I'm holding up the other side of the sign.
all right. Did the sign fall down or not?
We held it in place. Kathy and I did a good job that day.
All right. What about 183?
That is Kathy with a huge log of petrified forest. And that is the largest meteorite, or a piece of the meteor, that impacted in Arizona.
And then final photograph?
That is my birth mother, and Kathy and I. So we have 3 generations there. That was for her 90th birthday.
All right. Now, Mr. Lantis, when the defendant moved back to Florida to live with Kathy, was Kathy happy about that?
She was thrilled.
Now, during the time period when, like, since then, when he moved back to Florida and lived with her, did she try to make up for lost time?
She did.
And what were some of the activities that she and your grandson would do?
They had to catch up on 3 years of school. Collin was 3 years behind. And then they also caught up on the 4th year. So he got 4 years of education done in a single year. That's a huge accomplishment. They went to Australia, Central America, the Caribbean. She wanted to give him...
Sustain. Sustain.
Now, Mr. Volantis, what was your daughter's profession?
She was a teacher.
And what subject matter did she teach?
Mainly English, but she would do other humanities as well.
Now, tell briefly to the jury about your relationship with your grandson. Did you have a relationship with the defendant?
We would talk on the phone, but I'm not a helicopter parent. I was there to support him and to support Kathy and to love them and be there for them.
Based upon your personal observations, did it appear that the defendant trusted you and would talk to you and confide in you about certain things, grandfather, grandson topics?
Yes.
Did there come a time when the defendant said something to you that was very disturbing to you?
Yes.
Tell the jury about what the defendant said to you.
My grandson was very aggravated at his grandmother and his mother. He said, "I am so tired of these 2 bitches. I'm disgusted." He said, "My mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life and the blood leaving her body.
Now, when he said that, what went through your mind?
I needed to take a deep breath and do what I could to discourage that thought, because thoughts become words, words become actions.
What did you say to him in response?
I said, Collin, I love you, buddy, but you can't have those kinds of thoughts and focus on them and then speak them, because you will cause them to become reality. Please think positive things about your mom, about yourself, and about a good future together.
Now, at any point, did you warn your daughter about what the defendant was wanting to do to her?
I did, but I did not use the exact words because there was so much malice.
Objection, Judge.
Sustained.
Now, explain to the jury, were you concerned that if you used the exact words the defendant said that he wanted to do to his mom, that might negatively affect their mother-son relationship?
It would, and I was afraid it would actually give her nightmares.
Did you tell her a clean version or a more vanilla version, if you will?
Yes, I did.
What was her response?
That he's been threatening her, and he's been threatening Susan multiple times with killing both of them.
Now, knowing that, though, did she still want him in the household and want him to keep having the relationship with him?
Yes.
Mr. Wolantis, I don't have any other questions for you.
Thank you. Cross.
Good morning, sir.
Good morning.
Mr. Wolantis, you didn't come to Kathy's funeral, did you?
No.
Can you explain why?
The funeral for a person is for those left behind. I will see Kathy in my thoughts, in my mind. That's where I want to keep her. Attending a funeral where her body is placed in the ground, that's not Kathy. Kathy's spirit is elsewhere. The essence of Kathy is elsewhere. She's with me. She's here in this room today with each of you. She can speak to you. She can speak to me.
Mr. Wolantis,
Ma'am?
I asked whether you went to the funeral and why. Just answer that question, please.
You interrupted me as I was explaining why. That you don't like my response, ma'am, that's your problem.
Judge, would you please?
If you would avoid the commentary and you've asked the question.
I did ask the question, but then he's talking about her being present and speaking to the jury, which is non-responsive.
Sustained as to non-responsive, that portion.
Mr. Wolantis, the pictures showed a trip that you took with Kathy. That was one trip, right?
That's correct.
Have you taken any such trips with any of your other children?
No.
Do you have memory problems, Mr. Wolantis?
With what, ma'am?
Just in general.
Oh, sometimes I might think it was something that occurred a week ago, and it's actually a week and a half ago.
Okay. But that's the extent of your memory problems?
Usually, yes.
When was it that you say Collin told you that he wanted to slit his mother's throat?
I believe it was 4 months before she was murdered. It may have been before that.
And Judge, I'm going to ask that he be instructed not to use terms like that. That's for the jury to decide.
All right. Ladies and gentlemen, it is up to you to decide whether or not there was a murder in this case. You'll disregard that, the use of that word.
Mr. Willantis, please tell us the month, if you remember, that Collin supposedly told you the things that you've shared with the jury today.
May
May of what year?
2024,
Okay. And how did he tell you? Was it over the phone or by text?
over the phone.
Okay. And what's your phone number?
505. This is being broadcast. I really don't want everybody calling me.
Would you shut the feed off, please, for just a moment?
I was going to say, he doesn't need to be giving his phone number out.
It's on.
It's a,
All right. Ms.
Miss-
Thorne?
Mr. Willantis, do you have any other phone numbers that Collin would have talked to you on?
No,
And you're certain that the phone call happened in May of 2024, aren't you? Because you said it happened shortly before the presidential debate where Joseph Biden had to later withdraw from the presidential race, correct?
it was before that. How much before that? Was it a month? Was it a month and a half? Could it have been 2 months? Sure.
You came to court here in Florida back on January 14th of 2025, correct?
Yes.
And you rose your right hand, swore to tell the truth.
Yes.
Do you remember being asked this question and giving this answer? Question. Now, did your grandson, Collin Griffith, then at some later time make some very disturbing statements to you about what he wanted to do to your daughter, his mom? Answer. A few weeks before the disappointing presidential debate in June, which we can all snicker about, Collin was telling me, and then it goes on to repeat what you said earlier, but
Yes.
you remember saying it was a few weeks before the debate.
Yes.
Did you ever call the police about this statement that you claim Collin made to you?
I called the police here, yes.
Oh, I meant at the time that he made it to you, so in May of 2024, or a few weeks before the debate.
No.
Let's talk about your call to the police in September of 2024. You found out from your son, John, that Kathy died, correct?
Yes.
He called you.
Yes.
At some point after John called you and told you that, you watched a press conference that was put on by Sheriff Grady Judd, correct?
Yes.
And you watched it in its entirety, right?
Yes.
And it was about 20 minutes long, if you remember.
About, yes.
And Sheriff Judd described in detail how Kathy died, right?
Yes.
And it was only after you watched that press conference that you took the initiative to call the police here.
Yes.
They didn't contact you as a close member of Kathy's family to get any information from you, did they?
Initially, no.
Right, you contacted them.
Correct.
So you inserted yourself into the situation.
Yes.
Oh, I know what I was gonna ask, sorry. Mr. Walantis, how often would you say that you talk to your grandson Collin on the phone?
I don't know, somewhere between once a week, every 2 weeks.
For what
3
period of
weeks.
time?
It's up to him.
No, up until when? Like over the months since he had been living in Florida with his mom? Every week, every 2 weeks from,
Things dramatically decreased after we spoke at that time.
okay. So you say that it decreased after you spoke with him in probably May of 2024 and he made this supposed statement to you.
Yes,
Did you text with him still or no?
there may have been some. I don't recall every text, every phone call exactly.
So, Mr. Walantis, can you explain why in Collin's phone records there are a total of 3 phone calls between you two from mid-2023 till September of 2024?
Yes, I can explain why.
Okay. Why?
Well, there's Colin's phone. Colin had an initial phone that his mom got for him. Then he got another phone number. And then often when Kathy would talk, she would then hand her phone to Colin and we'd talk from there. So you have 3 different phones.
Oh, do you know what phone you talked to him on every week up until September of 2024?
On my phone, I
Right,
know that
the
much.
phone- the
Which
phone
one?
that he was using.
He was on one of the 3.
But only 3 calls on the phone that we are all aware of.
No, there's 3 phones, ma'am, not just one.
The records we have. Sorry.
Imagine how many know what the records you don't say.
Sustained.
And you said that there may have been some text messages. So the text messages that are shown by the records indicate that there have been no text messages between you and Collin since Father's Day of 2023 when he texted you Happy Father's Day. Does that make sense?
Most everything was phone calls. There were some texts since then between one of the 2 of Colin's phones.
Do you know where Collin kept this mysterious other phone?
I don't know about a mysterious phone, ma'am. I said there were 2 different phones he had. He had one phone number, and then he got another phone number. And that was something that he and Kathy arranged.
And this is something that Kathy told you.
No. He had one phone number, and I put it in for Collin Griffith. Then he told me that he had another phone number. His mom got him a different phone. So I put that phone number in, and then Kathy's phone, so that's the 3 phones.
I don't have any other questions.
Yeah, just read. Mr. Walantis, the defense said that you inserted yourself into this situation. Do you recall that?
Yes.
You are the deceased victim's father, correct?
Yes, I am.
Did you insert yourself into anything voluntarily?
When Collin and I spoke about that disturbing phone call, I told him that if anything happened, I would be talking with people officially instead of being quiet.
And does it make sense that the murdered victim's father calls law
Sustained.
Excuse me. Does it make sense that
Objection is calling for speculation.
Let me hear the question. Don't answer the question until I say so.
Yes, sir.
did it make sense that the deceased victim's father would contact law enforcement with important information as you did?
Sustained. It's for the jury to decide, Mr. Williams.
Now, when you called law enforcement on September 23rd of 2024, you told law enforcement the disturbing violent statement that the defendant made, correct?
I did.
I have nothing further.
Thank you. Is the witness released?
He is, Your Honor.
Ms. Thornhill?
I have no problem with it being released.
Thank you, sir.
Thank you, Judge.
Mr. Levine, is there a witness that we can call up before a reasonable lunch hour?
Your Honor, there's going to be a witness from out of county that's available at 1 o'clock. The only other witness for today is Detective Peters, which will be lengthy testimony.
All right. That witness is not due till 1, or might that witness be here at 12:30? Do you know?
The the out of county witness from Charlotte County Sheriff's Office won't be here until 1.
All right, ladies and gentlemen, you're going to have a more leisurely lunch today of about an hour and a half. That sounds like we have 2 more witnesses for the day and cannot start that until 1 o'clock. So please enjoy your lunch and leave your notepads in the chair. It occurred to me, by the way, yesterday that I think I forgot to tell you during the preliminary instructions, in case you're worried about it. No one's ever going to read your notes, including me. You'll be allowed to take them with you to the deliberations room so that you have your notes there when you're discussing the case. And when your deliberations are over, they'll be delivered to me and promptly destroyed in the shredder in my office, and I will not be reading them. So just so that you can rest assured of that. So please enjoy your lunch and report back at 1 o'clock.
All rise, please. May be seated.
Anything before the lunch hour and a half?
No, Your Honor. The first witness will be relatively short. There'll be one video clip played, and then Detective Peters will be longer, Your Honor.
All right, we're going to be finishing watching the ring clips through
Yes, Your
Detective
Honor.
Peters. All right. Plus, I'm assuming there's some other.
Yes, Your Honor. There's a number of text messages as well and some other things.
He's not your last witness, is he?
For today, he is,
Okay.
Your Honor.
So, but you're not resting today.
I'm not resting today, but as I was telling Ms. Thornhill earlier, on Monday, the state will be resting at some point.
All right. If you think you're going to be resting super early, it might be good to know that. While we'll have to take up whatever motion there may be and other matters it may be that Ms. Thornhill could get started with her case on Monday.
Yes, we discussed that, and she'll probably have witnesses available first thing in the morning in case there's not much presented by me.
Okay.
Yep, we've already taken care of it mostly.
All right. I like lawyers who think ahead.
All right, Judge, thank you.
All right. I'll see you after lunch.
So it appears there is a witness from out of town that can't make it until 1 o'clock, and then Detective Peters will be continuing on the stand. It's going to be an hour and a half lunch, so maybe set your timer or whatever you want to do if you are following this stream. Also, they stated it looks like the state's going to be resting on Monday, and then the defense will give their presentation. So we will see you guys in about an hour and a half. Hello, I'm doing a sound check. Hello, hello. 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 Hello.
You may be seated. All right, we're back on the record. Mr. Griffith is present with both lawyers. Mr. Levine is here for the state counsel. Lieutenant Uyghur with court security has something to report, and then I'll ask you how you want it addressed.
Good afternoon. We had two jurors have a situation at separate times with allied staff members at the entrance. One stated that the allied staff member made a comment to the effect of, I'm not verbatim, but luckily you're not in the trial with the kid that killed his mom. And then another juror had apparently the same individual said, yeah, you guys are in that mock trial, right? It's already going on. But she didn't understand what he meant, and I don't either. But either way, there were two comments made to two different jurors.
Mr. Levine,
I don't request anything, Your Honor.
Ms. Thornhill.
Based on what Lieutenant Uyghur has said, it sounds like it's nothing additional from what they already know. I guess we could ask the jurors exactly what they heard and if it affected how they felt about the case.
Which jurors are in? Mr. Hurtel, do you know? All right, if you could get their names and then just bring the first one in.
This is off the record. See, and here I was,
Kind of.
but that's okay. Here I was feeling confident that we'd made it past the possible mistrial, and then the
I'm
civil
still-
Qantas didn't
I'm still confident.
Go.
It went no further than that.
Yeah. Well, it sounds okay, but I don't know why.
I can let you know that that individual will not be working at the courthouse at any point from this point forward. So I can tell you, and all of the other allied staff are being given very strict reminders. They have already been trained that they are not to discuss, but we are reminding all of them and doing strict. But that individual person will not be working at the courthouse anymore going forward.
Thank you for that reassurance.
Unless you kind of put your chair back there. We have like a smaller one. Yeah.
Could you cut the audio feed, please?
Mary, hello. Hey, Mary, if you can hear me, I don't know what happened. I'm having some mic issues. Sorry about that.
indicated that you might have been exposed.
I don't know if you can hear me or not, but he apparently is talking to a juror. Let's see what happens.
welcome back. I hope you had a nice, long lunch. I want to ask before...
Sheriff's Office.
Deputy Christopher Ellis.
Your Honor, may we bring audio?
Oh, yes, of course.
Step to play, please. And here, raise your right hand and report to someone.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Good afternoon. Remain quiet.
All right. Good afternoon, Dr. Ellis. Are you a doctor? All right. Deputy Ellis, could you please introduce yourself to the jury?
I'm Deputy Ellis, Charlotte County Sheriff's Office.
And how long have you been employed in law enforcement?
I've been involved in law enforcement for 9 years. I worked for Charlotte County for 2.
Could you give us your first name?
Oh, sorry, Christopher Ellis.
Thank you.
And what are the different divisions you've worked in, or units that you've worked in?
I'm sorry, say it one more time.
What are the different units that you've worked in law enforcement?
I worked in Louisville, Kentucky, for Louisville Metro Police Department. Worked in for 5 years. With them, I did a little bit of the division level task force team, apprehending subjects and drug traffickers. Moved to Florida, worked for Bradenton Police Department, and then now I work for Charlotte County.
All right, Deputy Ellis, I want to direct your attention to a specific date. On November 14th of 2023 in the morning time, did you respond to an address, a residence in Port Charlotte, based upon a report you received that the defendant made statements that if deputies made him get in the car with his mom, he would kill her?
Yes,
And where was that statement made? Where was the defendant when he made that statement?
at the Charlotte County Jail.
And was that on the day prior to you responding to the residence?
Yes.
The morning of November 14th, describe to the jury the reason for you responding to their residence.
I received my sergeant received a call and stated that the defendant had made a statement that he was going to kill his mom if he was forced to get into the car with her. We went to the residence, the defendant's residence, spoke with him, ultimately placing him under a Baker Act.
And what was the reason that you placed him under a Baker Act?
From the statement saying that he was going to kill his mom at the jail, and just speaking with him not knowing what he was going to do while he was at the home with his mom.
Now, were you wearing a body cam when you interacted with the defendant and his mom at their residence?
Yes,
And was Corporal Joey Shaw also with you?
yes,
And did your body cam capture some footage of your interaction and Corporal Shaw speaking to the defendant?
yes,
Did you have an opportunity to see State Exhibit 194 briefly before court today?
yes.
Your Honor, at this time, the state would move State 194 into evidence.
Any objection?
No objection.
It is received.
And with the court's permission, if I may publish that, Your Honor?
You may.
Thank you. John, there should be a John.
White 2020 Volkswagen Four-Door from Catherine and Griffith of 2024 Business Story Avenue, Port Charlotte, Dallas 39425. Thank you, one.
Hey, somebody.
Hello.
Hello.
Hey, how you guys doing?
Good. Is Colin home?
Yeah, you guys can come on in. He's doing Sandy marches. He's not a happy camper right now. You can put your marching bells on.
What's up, man? What are you doing?
He's doing standing marches as a form of discipline ever since he got home. I have that right there recording it so you can see everything. I'm sorry? Do what? Just so you know, it's being recorded because as soon as he got home, I had him start doing standing marches.
Is that working?
I mean, he beat the shit out of me last night, so
Right.
this is his form of discipline for.
That's something for a judge to decide.
Okay.
Can we,
Yeah, we'll go
just gonna
outside.
talk to him a little, okay? Just, I wanna talk to her, we'll just figure out what happened.
Yes.
So what's going on, man?
Last night, me and my mom got into a physical altercation. I got arrested for domestic battery, but I'm going to come to judge today. I have a right to public defender, and we'll see how that goes.
Okay. So how is the situation with you and mom right now? Have things calmed down?
No,
you guys
no,
everybody's
no,
get along? Where are we at?
No, sir, it's not good. She thinks that I do shut of her. I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her. I want to kill her, but I want to beat the shit out of her.
Do you?
No, sir.
Okay.
I don't want to hurt anyone, let alone my mom. Even despite this happening, but I'm not gonna take what I consider abuse when someone's attacking me. And
How is she attacking you? What
when
kind of
she
abuse are we talking?
attacked me, when she threw a punch at me and grabbed on me, I grabbed onto her back. I got her off of me. She hit the ground, and then I fled and called Rentis, and then he sent someone out.
You called who?
Rentis, Detective Rentis.
Okay. So basically what we came back is when the jail was releasing you to your mom this morning, was there anything said then?
Yeah, I said that I didn't really feel safe there with myself and with her, and that I didn't know what was going to happen. I still don't know what's going to happen.
As far as what?
Her attacking me or her doing something to herself or me.
Okay, what about you doing something to her? Are you able to control yourself?
I'm in a constant state of fight or flight, and I don't know. If I think she's going to do something, even if she's not, I might act. I'm not going to like go crazy or anything, but I'm not sure, honestly.
Okay.
You're not sure if you're gonna hurt your mom?
Only if she tries to hurt me.
Okay. Did you make any statement saying that you were gonna kill
No,
your
sir.
mom
No,
if
sir.
you got in the car with her?
No,
I'm
sir.
trying to figure out why we would have a corporal at the jail that took you out, that dropped you off with your mom and telling us that you said, don't put me in the car with her, I'm gonna kill her.
Yeah,
Was that said?
I did not say I was going to kill her. I did not say kill. I don't know why he sent me back here. I asked him not to, but he said he didn't like my attitude and that I had to just work. He said that. But his words are mine.
home from the jail when you all arrived at the house?
I have no idea.
You don't know when the sergeant from the jail called to make this report?
No, ma'am. I just received the information from my sergeant.
So he could have been home for hours by the time you got there.
Possible.
Possible? When you first walked in to the home, Collin was standing with 2 weights over his head and doing marching in place, correct?
Just one.
Just 1 weight?
Yes, ma'am.
Oh, sorry, 1 weight. And Kathy Griffith had indicated to you that she had been making him do that since he got home from the jail, right?
Yes, ma'am.
If Collin had wanted to kill her, unprovoked, unattacked, he could have hit her in the head with that weight that he was holding over his head, couldn't he?
It's possible.
He could have done something while they were driving home in the car together, right?
Possible.
But he didn't do any of those things that you're aware of.
Yes, ma'am.
And he told you repeatedly that he didn't want to do anything to his mom, but that if she attacked him or if she came at him, that he would do something in response to her attacking him, right?
Yes, ma'am.
Redirect.
Deputy Ellis, would it be smart to murder someone in a house that's got video cameras in every room?
No.
I don't have anything further on.
Is the witness released?
Yes, sir.
Ms. Thornhill?
Yes.
Thank you, sir.
Sir.
Next witness?
Your Honor, the state calls Detective Danny Peters of the Polk County Sheriff's Office.
So Danny Peters is returning to the stand.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing?
Hello again.
Hello, sir.
Mr. Levine.
Detective Peters, we left off with your portion of the testimony yesterday afternoon. We concluded with the ring video footage from September 7th, 2024, which was a Saturday. Is that correct?
Correct.
And at that point that the defendant had left the house and Kathy was in the house by herself, correct?
Correct.
Is there also an exhibit in the form of 198 that captures some clips from Sunday, September 8th?
There is.
Was that the day that Kathy died?
Yes.
Later that day?
Yes.
Your Honor, at this time, the state would move state 198 into evidence and ask that it be played for the jury.
Any objection?
No objection.
It is received. You may publish.
Thank you. Is this clip at least from the early morning hours of Sunday, September 8th?
Yes.
No, you told me you were calling him. You told me you were going to get your neighbor over there, or I'm sending the police. Do you want the police to go? Then you would rather have the police go. Okay, that's fine. That's the only answer I needed. I will not take a call from you after this ever again. If Colin's not here by 10 o'clock, I'm dead to you. Do you understand me? Do you understand me? Do you understand me? Do you understand me? Yes or no? I need a yes or no. Yes or no? Do you understand me? Okay. You don't understand. And on your little, you want a copy of the pink piece of paper that shows it? Call me. Call Detective Lacey. Call them. So are you returning home or no? Look at the pictures. Okay, it doesn't matter. You were knowing with me, and you lied to me while we were here. I said, do you have him? You said no, and I don't know where he is. You said that to me. Okay, it doesn't matter. It doesn't matter because you still don't have eyes on him. He's talked to you. No, he's already talked to you because I can see where you guys have been talking. So if he's not here by 10 o'clock, I'm sending the cops. Oh, it is. It is. We're all losing our jobs, and he's losing everything. That's why I signed the car over to myself. I need the money. So I'm taking the car. I'm taking everything. So I'm about to go up there and go and get the car because the car is mine. I have it in my name. The mobile notary came. I don't have to send you copies. I already sent you the title. I already sent you a picture of the title, and you already saw what it looked like, so I'm not going to sit here. Okay, then you need to go back through the pictures. because you also said you don't have the pink picture that shows it. You also said that you don't show the call records and that you believe Collin, even though he's there at your house. So you're illegally in the law. Tell him for house and that he has to go back home. Is that correct? No. I'm asking you a specific question. Have you told him he needs to go back to this house? No. Did you tell him he needs to be back home to this house by 10 a.m.? That he needs to vacate your house? He does not have permission to be at your home. No.
That's what I told him.
Okay. Okay, and that's not what he did. He called me and he said, he completely blocked me, and he's completely removed himself from his Apple ID so that he cannot be tracked. So, right on that. No, his phone is off. His phone is off now. I told you that. I said if he didn't get in the car and come home, that was what was going to happen. And you said I will make sure he is there by 10 a.m. I told you I was going to if you didn't do this. No, that's not what I said. His phone is still on right now. His service is working. He's not going to answer. He's not going to answer. I showed you. Oh, stop. Will you listen to me? Do you see the call log? He did not try to call Monique at all yesterday. He is lying to you. I sent you his entire call log. That's from AT&T. That's not from his iCloud account. That's from AT&T. That's not what the court order said. It said he specifically has to leave a voicemail. But it doesn't matter, because if he doesn't, that's fine. But I'm telling you right now, I have held everybody off. I said it's a private family matter. I'm sure he'll be back home. And everybody said, we'll give him 24 hours. That is until 10 o'clock today, Mom. That's why I said he had until 10 a.m. today. Mom, it doesn't matter. They gave me until 10 a.m. The police. I'm not speaking to you anymore. Either my son is in my driveway at 10 a.m. or we're not talking anymore. Okay, that's fine. You don't want to talk to me? That's fine. Goodbye. Back after work. It's on the fucking camera! I don't give a shit. I don't give a flying fuck. Did I tell you to let him stay at your house? Did I tell you to let him stay at your house? Have I not told you multiple times in the past that he is never to stay at your house ever again? Not without my consent. And I have not consented. Do you hear me? Ask Collin. Answer to me. Answer me. Do you understand that you do not have my consent to have Collin? Do you understand that? No, answer my question. Do you understand? No, I didn't. I never threw him out, and it's on the ring camera. Never threw him out. Never threw him out. Collin needs to be returned to me immediately. If when you arrive at your home, Collin is at your home, please inform him he is immediately. If neither of those things happen, and I find out that he is still in your custody, I am standing in front of my ring camera having this conversation with you on speakerphone. I expect Collin to be here back at my house. And if he's not back by 10 a.m., I'm going to take it if you are holding him hostage and not giving him back to me. Thank you. I hope you have a great day. Goodbye. So I'll go with you, and I can drive your car, or you can drive the other Jetta, and I'll just follow you. And I was like, okay. So his aunt lives there. I tried to go in, looked, it's not, his car isn't there. So I don't know where he parked it, where he put it. I don't know because I sent a text that said, hey, I'm selling your car. He decided to drive off with it. That was stupid because I'm signing this over to them, and they said that they'll just report it stolen. So if he's caught, excuse me. So also, in order for him to have a driver's license, I have to give my consent. Okay, otherwise they have to wait until they're 18. The fact that his name is on the title is there. That come on, Cass. Come on, Cass. Hi, this is Collin Griffith. I'm actually Collin Griffith's mom. I was just calling to confirm, did Collin quit yesterday? Collin Griffith, yeah, when he called in, I know he didn't show up to work yesterday. Did he quit yesterday as well? I just need to know. Is there a way you can find out for me? This is his mom, because he hasn't come home. So we're trying to find him. Yeah. Yeah, I talked that Brett is talking to me. I'm gonna call me back. Okay. Yeah, I just need to know if Collin told him that he was quitting or what he said. Collin is missing and hasn't been home in almost 24 hours. Okay, thank you. Thank you. this John turned on you. But you won't, and that's the problem. He's had it turned on Do Not Disturb. He called me at 7:32 this morning and talked to me for 56 seconds and told me I was a crazy psychotic bitch and he wasn't leaving and that he was going to stay there with Mama and that that's not a violation of his probation. I sent him a picture. Like, if he's sending you all these things, did he send you the pink picture that I sent to him that shows specifically, like, the pink sheet of paper they gave me that says he can leave the county to go visit his grandma? But it doesn't say he can leave the county to go visit his grandma, and that's what he thinks it means. And he thinks it means without my permission, he can just leave and go and do that. Oh, yeah, everything's not good. No, it doesn't, because I specifically said, how are you going to live on your own? No, I even told our girls, no, I'm not leaving for this 18. You and I both know. Yes, I'm sleeping. This is all. I guess I'm just crazy. You tell me, just sit back and stay with your mom. You'll sit and eat. I go. Piece of shit that drives me crazy, or we're not. So he wants to do this. He wants to go to court. That's what he wants. He wants this. That's what he wants. I didn't change my phone. No, I changed the voicemail to say that nobody could call me. That was all I did. No, Mom, you're a fucking moron. My phone was never disconnected because if you would have tried to send a text, it would have showed you that it would have gone through. I went onto YouTube, pressed play for the I leave the girls in the house. We already didn't show up to work yesterday, and instead, want to know where he went? The movies. I'll show you the receipt. He went to the movie theater. And you know what he's been doing all day while he's at your house? Because it's showing up every time he takes a screenshot of it on his iPad account. He's playing video games, killing people. And I send those screenshots to you. So tell me how he's better off at your house where he's killing people. Pretend and making fun of it. And kidnapping them and having them tied to little chairs while he tortures them and kills them with other people in this little game scenario that he has. I sent you pictures of the screenshots where they're I'm calling you right now. Oh, you're not! Because I'm driving up there. Listen to me. I'm going to be there before you. So it's going to go down before you even get there. I don't know what to tell you. I guess you can call Collin and tell him to run, or try to run, because I'm coming up there. I'm getting the car is sold. He can either get in the car with me and come back home, or he can call, then you better tell him that he needs to give me a goddamn phone call in 10 minutes. He has 10 minutes. Because he's answering your calls, he's not answering mine. He's answering Lacey's, not answering mine. He has me blocked. So are you going to call my son and tell him what I just told you? Call him and call me back.
Thanks for calling. State your name, number, and then play call, and I'll be back in a second. At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Hi, Collin. This is your mom. I am just calling you because I know you talked to Detective Lacey. She told you that you needed to be home today, and apparently you said no, you're not coming home. And so you were explained the situation and that if you don't come home, you are going to be charged with violating your probation. So I'm just warning you, I am on my way to you to pick you up because you're not allowed to stay away from me like this. You're not allowed to be a mama's house, and I have every right to come and pick you up. So I'm coming to pick you up. You can get in the car or not get in the car. Right away. It's up to you.
Okay, yeah. All right. Your call has been automatic.
I threw him out and told him to come back when we got his shit together. Yes, I did. Okay, it doesn't matter. Check your text. Okay, because it never said that via text. So have fucking fun with it. I'm on my way. Oh, do you need to get Carter or no? Do I need to wait for the police to get there? Okay, we'll see. We'll see. Here's something. It actually is less. Go ahead. He has work from 4:30 to 8 today. 4:30 to 8:30. So, yeah. You have 9 minutes to call and tell me that. I mean, I'm getting in the car right now. I mean, I'm peeing. Then I'm getting back in the car and I'm going to pick him up. And if once I'm in the car, you haven't called me and told me anything, but that's not how it works because he still has to go see Monique, and he sent Monique an email saying that he knows he violated his probation. You have, and it's 2:53. It's less than 7 minutes. Goodbye. Here's my bear. You don't know. He won't answer when I call, so good luck. Tell him to do this right away. Tell him to do this. I thought he was going to work. No. I don't throw him out all the time. That's a lie. Do you plan on going to there and telling them that I throw him out all the time?
Was the last video that the jury saw the last video that captured Kathy alive?
Yes.
And did she leave the house in the clothes that she would die in?
Yes.
And did she have the brownish, yellowish Kate Spade backpack purse kind of over her shoulder?
She did.
And did you see that at the crime scene?
I did.
Was it soaked in blood?
It had blood on it, yes.
Now, let's switch subject matter for a moment now. Done with the videos, going to text messages. I believe you mentioned yesterday the basic process of getting forensic downloads and information off the cell phones. Were you able to, from those cell phones, something called a Cellbrite extraction report, generate a Cellbrite extraction report that detailed text messages on September 7th and September 8th?
Yes.
Describe to the jury a little bit. What does that mean, a Cellbrite extraction report?
It's just a report that's generated from the program that's used to download the phones through our computer crimes division.
From that, were you able to basically see all of the text messages between Kathy and the defendant on those last 2 days, the Saturday, September 7th, and Sunday, September 8th?
Yes.
Were you also able to see the text messages between Kathy and her mom, Susan?
Yes.
And as the timeline kind of continues, and we'll focus obviously on those 2 days, would there be periodically photographs or pictures or attachments that Kathy would send to either her mom and or her son?
Yes.
And then some of those, were you able to kind of click on and print out?
Yes, I was.
Some of them, for some reason, is the pixelation such that you can't really see what it is for whatever reason?
Right. So some of the photographs, when you try to enhance them, they wouldn't enhance like through high definition. It would be completely pixelated and you wouldn't be able to tell what was in the photograph.
As far as you can tell, though, was there anything of major importance that you weren't able to see?
No.
Now, have you had an opportunity to see State Exhibit 188, which is the Cellbrite reports containing text messages and some photos from September 7th through September 8th between Kathy and her son?
Yes.
And were those obtained off of the defendant's cell phone?
Yes.
So is it a fair statement, even though that it was not possible to get a download from Kathy's phone, you were still able to see the content of the conversation because defendant's phone was able to be downloaded?
Yes.
At this time, Your Honor, the state would move State Exhibit 188 into evidence.
Any objection?
No objection.
It is received.
And then 196, Detective Peters, is that a similar exhibit but from Susan Detman's phone?
Yes.
And does that show text message conversations between Kathy and Susan?
Yes, it does.
Your Honor, at this time, the state would move State Exhibit 196 in evidence.
Any objection?
No objection.
It is received.
And for the record, that includes the text messages from September 8th between the two ladies, correct?
Correct.
Now, from watching the videos, is it a fair statement that sometimes you can actually see Kathy sending texts or taking photos and then sending them to her mom or to the defendant?
It appears that she's texting and sending photos to someone in that moment.
And conversation-wise, are you able to see some things that Kathy refers to her mom, text messages that she sent as well, and subject matter that she was sending off to her son, the defendant?
Yes.
Now, did you come across, or did one of your expert computer crimes detectives come across a text message of note that was brought to your attention about an additional motive that the defendant had to kill his mom?
Yes.
Tell the jury just briefly, how did that come to your attention?
So, early morning on the 9th of September, I received a phone call from our computer crimes detective who was going through the download and explained to me they found an interesting text message that I needed to be aware of.
After reviewing that, were you able to create an exhibit within an exhibit, so to say, meaning you isolated that specific text message and it was able to show the date and the time?
I did.
All right, we'll start with that, and then we'll backtrack to the text message conversations between Kathy and her son and Kathy and her mom.
Okay.
And for the record, this is a composite 188. I'll bring this to you so you can read it to the jury, but for their benefit, just so they can see visually what it looks like, we'll put it on the Elmo here. All right, this is basically a cover page of the Cellbrite extraction report.
Yes.
And then is that how it generally looks in terms of you can figure out the date, the time, who sent it, who received it, and the content of the text message?
Yes, it does.
And if I may approach, Your Honor?
You may.
Detective Peters, the jury will obviously have the benefit of this in the deliberation room to look at it up close. But if you could please, actually, before I get to that, mirroring that text message, were you able to also get a screenshot? Actually, if I may approach, please, Your Honor? Thank you. And I'm going to show what's also part of the composite 188 so the jury can see, and then you'll be able to explain it further. If you could please, Detective Peters, explain to the jury those three screenshots, what are those pictures of?
These screenshots are photographs of conversation between Catherine and Collin.
And at the top of the screen, what's the picture and name?
The picture is of Collin Griffith, and underneath it says Mom.
And whose phone did that come off of?
Collin Griffith's phone.
And how did you actually obtain a picture like that?
These photographs were copied in a screenshot format that was in the photographs.
So you were able to get screenshots of the defendant's phone conversation with his mom, is that correct?
Yes.
And is that the text, the full text conversation regarding another one of the motives the defendant had?
Yes.
All right, if you could please read the full context of the text message.
You want me to read this one or the Cellbrite?
The one in your right hand is the full one.
Okay.
But before you get there, can you tell the jury, according to the Cellbrite report, is that sent by the mom to her son, the defendant?
Yes.
And a time that it was sent and or typed?
Yes.
What's the time?
The time is 12:02 p.m.
And that would be on Sunday, September
Correct.
8th?
September 8th, 2024.
And then on the cell phone, what does it say? The time?
12:29.
All right, so at or between 12:02 and 12:29, the message is sent, typed, received. Is that correct?
Correct.
All right, if you could, go ahead and read the full content of the text message.
Okay. Begins, the car isn't there, not sure what you did, but it's being sold as we speak to CarMax for $15,600. Unless you'd like to reply to my text and tell me you're driving home right now. Period. Didn't think so. It's a felony to drive a stolen car without insurance, and if you wreck it, that's it. How much are you going to lose before you stop, Collin? ? I feel like you are trying to make me like your dad by talking away privileges, but you violated your probation, violated the rules of the house, and now you won't answer me. My mom or the cops, you've left me with no choice. Collin, the recordings of you admitting to killing blank and planning the murder, there are 4 different instances from my Ring camera, are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. Plus the recovered audio from blank's iCloud where you told your blank you hated me and I was an evil bitch are being sent to. My dad is sending his recordings of you telling him how you planned my murder back in February. Audio, video, email, text, and phone recordings are being sent. For the record, no, you cannot have a single one. Your attorney can request them. Good luck hiring a good one. And this goes into the next screenshot. Because the 751 clearly states I have to be medically incapable of caring for you, and I am not. You can keep hiding and running away from me. It is illegal for your grandmother to allow you to stay at an empty house 3 hours away when she was in Summerlin Key, which was on speaker and recorded as saying, I almost had an Amber Alert issued until she admitted after midnight you were in Auburndale, which is why I agreed to give you until 10 a.m. to cool down and come home, but I made it very clear you didn't come home. I legally don't have a choice but to report you as a runaway. Mama complained about you in February, you threatened her in February, but all of a sudden you go back to her and she takes you in, and I'm supposed to just let her steal you when I'm legally responsible and now in trouble for not reporting you as a runaway last night and waiting until this morning. That's not how this works. I'm giving the police your number, Mama's number, and DCF's all numbers now. They also have all 3 addresses. Also, Freddie is not registered in Polk County. And this goes over to the 3rd screenshot, and I have to go down to where it begins. Also, Freddie is not registered in Polk County with a dog tag. That's a fine, and Mama owes taxes on her other trailer she sold in the same neighborhood. Her HOA doesn't like you or her. The police are going to bring you home, or DCFs will take you and eventually bring you home. Either way, you fucked up and list your chance to get off probation by October 5th, 2024. All because you didn't want to help me mount a bookshelf that took under 30 minutes. Weed eat the backyard and clean your room because bugs were in the candy that you had all over. Remember, you chose this. You have 10 minutes to call me and fix this, Collin. I am signing this title and handing over the keys now.
So Detective Peters, that was roughly around 12 and 12:30 in the afternoon, correct?
Correct.
And Kathy would end up dead with a 911 call around 6:14 that same day, correct?
Yes.
So roughly around 6 hours later, is that correct?
Yes.
Now, I want to focus for a minute on the main part of that text. Collin, the recordings of you admitting to killing, you said blank,
Blank.
did you? Right, but
It's
she mentions the name, correct?
Correct.
And planning the murder, there are 4 different instances from my Ring camera are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. So is she threatening him to expose him for him admitting to her that the killing previously was actually a planned murder?
That's what the text message indicates, yes.
And then was she also planning on sending recordings of the defendant calling her an evil bitch?
Yes.
Was she also threatening that her dad would be sending his recordings of the defendant telling him, the dad, meaning the grandpa, that the defendant planned his mom's murder back in February?
Yes.
Now, was it clear from your review of everything that on the September 7th, or more so on the September 8th date, I guess, but that the defendant was having much more contact, like speaking to his grandma, than with his mom?
Yes.
And was Kathy hopeful that her mom would like pass on information that Kathy wanted Collin to know?
Yes.
With the hope of what was Kathy's hope stated over and over? What was she trying to accomplish?
Objection, Judge. She doesn't know what her hope was.
Did Kathy say on multiple occasions that she wanted or demanded that Collin return home by 10 a.m. on Sunday?
Yes.
Did she make any threats whatsoever of physical violence to the defendant in any of the text messages or phone calls?
No, not that I read.
Did she make a bunch of threats that doesn't appear she followed through on, such as canceling his phone service or shutting it down?
Yeah, it appeared she made threats to close it down permanently, but it was on and off sporadically.
Did she make threats to cancel his car insurance?
Yes.
Did she make threats to sell his car?
Yes.
Did she make threats at some point to like take him out of school or disenroll him?
Yes.
Now, turning to State 196, did she also send a similar text message to Susan, explaining to Susan, her mom, that she was going to be turning over videos of the defendant admitting to killing the person and planning the murder from the year prior?
Yeah, she wasn't getting the response from the defendant, so she texted the same text message just advising her to tell him the same text that I read.
And I'm going to approach with State Exhibit 196. But before I do that, we'll stay just to be able to show the jury visually what it looks like. A cover page is at this Cellbrite report, where basically it goes in chronological order: date, time, who sent the message, who received the message, and the content of the message.
Yes.
And of course, this exhibit I referenced is the text messages on September 8th between Kathy and Susan. Is that correct?
Correct.
So as the day progresses, I'm going to direct your attention specifically to page 25 for purposes of the record.
correct me if I'm wrong, but if you could look at page 1 first, does that appear that text message conversation begins at roughly 3:50 a.m. on early Sunday morning, September 8th,
Yes, it does.
and continues obviously throughout the day? Look at page 25, which I also
Separated.
handed to you.
Yes.
What time on Sunday?
How he planned my murder back in February. Audio, video, email, texts, and phone records are all being sent. For the record, no, you cannot have a single one. Your attorney can request them. So can Collins. Good luck hiring one because the 751 clearly states I have to be medically incapable of caring for Collin, and I'm not. You can't keep him from me. You can't hide him. He can't allow him to stay at an empty house 3 hours away when he blew up my microwave. You complained about him. He threatened you in February, but all of a sudden you take him in and I'm supposed to just let you steal my son. That's not how this works. Have your attorney call Eric Reyes on Monday so they can coordinate. I know you won't return Collin, and I know he is hiding because the car is not there at your house. I'm giving the police your number and DCF's your number now. They also have all 3 addresses. Also, your dog Freddie is not registered in Polk County with a dog tag. That's a fine. And you owe taxes on your other trailer you sold in the same neighborhood, and the HOA doesn't like you.
So is it a fair statement that Kathy told both the defendant and Kathy told her mom that she was aware of the way Collin had told Mr. Wantis he was going to murder her?
Yes.
So that wasn't just known by Robert Wantis, but Kathy knew that, correct?
Sustained.
Is one of the last things that was heard on the ring footage that Kathy was giving the defendant two options, either get in the car with her, or 3 options: get in the car with her, follow her in his own car, or she would call the police.
Objection, Judge, I think that's a mischaracterization. That was between her and Susan, that phone call.
Do you recall similar text message things about that?
Yes.
Now, I mentioned earlier about some of the photographs that would be attached to certain text messages that would be sent between Kathy and her mom, and Kathy and the defendant. Going back to 188 to publish some of those photographs. Do you recall from yesterday, Detective Peters, the chores that the mom was unhappy with Collin not doing?
Yes.
Did Kathy end up doing the chores herself?
Yes, she did.
And did she send text messages to her son where she showed him how easy it was for her to complete the chores?
Yes, with photographs of the areas that she cleaned.
And is now publishing for the jury's benefit from 188. Is that I don't know if that's a video or a screenshot of a video, but from the living room of her working?
Yes, that's a screenshot from the Ring camera in the living room.
That would have been on Saturday, 3:37, is that correct?
Yes.
After the defendant already left the house?
Yes.
Tell the jury about what Kathy's doing in her backyard there.
That's the backyard of their residence, and she appears to be rolling up some extension cord connected to what I would say is a weed eater.
And what day, time on Saturday, September 7th, did she do that?
6:20 p.m.
What can you tell us about that?
That's a Ring camera connected to the front of the residence. Appears she's taking out garbage.
What time on Saturday?
4:47 p.m.
What can you tell us about the time and what she's doing in that photograph, if you can tell?
Appears that she's cleaning like was observed in the video yesterday, and that's at 3:37 p.m. from the living room Ring camera.
And then a photo, what was in that, what subject matter was that in reference to?
That's the call log in reference to her attempting to contact Collin.
Now, of course, there's many pages of text messages. Does the subject matter stay pretty consistent between Kathy and Collin?
It does.
Now, finishing up with the Cellbrite report, going to 196, some of the photographs, correct me if I'm wrong, but some of the attachments / photographs that were accompanied by text message that Kathy sent Susan. We'll begin with a certain one. What can you tell us about that, Detective Peters?
It appears to be a screenshot of a conversation between Catherine and Collin.
And help explain at the top of the screen, what does it say and whose phone would this be?
It says collin.griffith@icloud.com. That'd be Collin's phone.
And read to the jury, if you would, what the conversation between Kathy and her son was.
It says, Mom, believe coming from Collin. She's, Collin, what's going on? He says, you told me to leave. She says, I told you to leave because you were scaring me. You hurt me, Collin. He writes, I'm not doing this with you. And then a continuing text message says, Collin, you need to stop before this gets way worse. If you don't come home soon, you're going to face charges, serious ones. Just stop. This sane thing a year later, why? You just have to stop, Collin.
Now this one, there's a little different icon at the top. Can you tell the jury what that is?
That's an icon of the defendant with his name underneath of it as a contact.
And what does this message say?
From where it starts is, you want to throw your, and I'm assuming that says life, away like this and hurt me. I'll let everyone see you for who you are. All the comments and admissions made on Ring camera. You chose Collin now, or you choose Collin now. Respond that you will be home by 10 a.m. today. That's in 2.5 hours. Or don't respond and go back to court. You choose as always. And that's the last read you get at 7:28 a.m. Remember that you chose not to respond and instead just read the text.
Another photo of screenshots?
Screenshots appears to be a photograph, maybe of some court documents. And then the bottom says, you do not have my permission, and you did not call Monique yesterday and notify her. You would be going, and it doesn't matter because you have to have my permission to, which you don't, and you've read my messages and called me and still refused to come home. Probation violations out the ass. You have until 10 a.m. That's it.
And then, what is that?
That is the phone log. That appears to be a screenshot of a voicemail.
And was the subject matter between Kathy sent to Susan, was it largely revolving around Kathy trying to get Collin to come back home?
Yes.
Did Kathy make any threats to Susan in the text message that she was going to do physical harm to Collin?
No.
If I might have a brief moment, Your Honor. I don't have any further questions right now, Your Honor.
Thoughts?
Judge, could we take our mid-afternoon break first? Thanks.
All right, folks, we'll take 15 minutes. Please leave your notepads in your chairs.
All right, please.
I don't know if you guys can hear me or not. I'm having some internet issues, so please forgive me for not having this lined out. We'll be back shortly. Okay. I think I have everything going. Please accept my apologies. We do, from time to time, in the development where we are, they'll hit cable lines. But anyhow, neither here nor there. That was insane. It sounds like there was conflict, not just Colin and his mom, but Colin's grandmother. She was in the middle of this. I know she was trying to help, but it just seems so messy. So messy. And the realistic thing about this, nobody deserves to be having their life taken away. I have to be careful what I say online, but it's just sad. I don't know why Colin's grandmother didn't call the police, somehow have this interfered or interject this whole situation. It's just beyond me. I mean, I know families fight over crazy stuff, but this was just beyond. I'm just still blown. I'm almost without words what to say. Um, I don't know how the jury's taken all this. And then secondly, I was away listening on my other headset because I had to deal with a business phone call. But anyways, I felt like they opened the door in his dad's stuff. So I don't know. You guys, please share your thoughts down below. I'm curious of what y'all guys think on this whole situation. I'm sorry to hear that, Mary. You know what? Some people with medical issues, it may be a little different. They're struggling and having their own issues within. Hopefully, that does resolve. I mean, it's just, it's sad. You know, it's all medical. Think about mental issues. And, you know, I clearly think the whole entire Griffith family, now the Walantas family, I don't know. I think grandma was trying to play mediator, you know, between Colin and his mom, but then it was beyond what she could do. I absolutely agree with you. She was trying to protect Colin. But I think also maybe, I don't know how that works. It just seemed, I can't even think straight right now. Listening to all that literally sent me into another realm of thinking. It's crazy. That's okay. You don't have to talk much. I'm not a big talker either. I'm just kind of rattling off right now because I'm in shock. I mean, I really honestly, I don't even know if Robert Walantas and Susan are even married and how he and her think about his testimony versus what's been said. That's another thing. I have no idea. I'm assuming she lived on her own based off court documents because reading through them, it never mentions him there at that retirement community. So, ugh, this is a sticky one, guys. This is a sticky case. I just don't know how the jurors are going to see that. But I think even though it went back and he had threatened to kill her or telling someone threatening to kill his mom, then we go back to Oklahoma. So I don't know. I wished Oklahoma, they claim that they opened or looking into that, but I went through their court records and I see nothing unless it's through Lincoln County Sheriff's Department. I don't know. But nobody deserves to have their life taken away. That's all I got to say. Right or wrong, conflict or no conflict. I was also going to tell you, Mary, though, they do things different in the United States. I believe you say you're from Australia. So the way our court system's set up may be totally different from the way it is in Australia.
Well, I'm the DOP paperwork judge today. I have a couple of things to take care of while we wait for Mr. Levine.
And I can tell Your Honor that they're working on, I think, some further redactions, because there were some words, I'll wait till Mr. Levine gets that.
Please be seated. Thornhill Cross.
Yes, thank you. Detective Peters, I wanted to flesh out some of the things that you mentioned on your direct testimony. And that was included in the ring videos and the text messages.
Okay.
In the ring video from September 8th, where Kathy is talking about, and you know what he's doing at your house? This is with Susan. He's playing video games where he's murdering and torturing people. Do you remember that?
Yes.
And her conversation implied that she sent some screenshots of that video game to Susan to prove her point.
Yes.
Right? And you've looked through the phone downloads?
Yes.
Okay, I'm going to approach and show you what's been marked as Defense Exhibit 1 and Defense Exhibit 2 and see if you recognize them.
Yes.
Okay. And do those appear to be the screenshots that accompanied the text regarding the video games that Collin was playing?
Yes.
Judge, I believe Defense Exhibit 1 and 2?
Any objection, despite it's your case right now?
Oh, well,
No, Judge, that's not.
I should have asked about doing things out of order.
They are received.
So this is Defense Exhibit 1. Take a minute. And do you know anything about this video game that's shown in the screenshot?
I do.
It's a Roblox game, correct?
Correct.
Rated for kids, like, as young
All
as
ages,
10,
up
all
up to
ages.
adults play it.
Right. But it's not limited to, say, adults only because of its violent nature or anything?
Correct.
Okay. And I'll show what's been admitted as Defense Exhibit 2. Same video game?
Yes.
So not quite as Kathy described it.
Yes.
Okay. Now I'm going to jump around a little bit. Going back to the house at 77 Hewlett Drive. You said that it did not appear that there had been a long, drawn-out fight throughout the house.
Correct.
But by the same token, if someone is being dragged throughout a house by their hair, wouldn't you expect they would be struggling against that?
Would I expect there to be struggling? Yes.
Unless they were going willingly with the person into
Sure.
and throughout the house. Right.
That's the other option, yes.
Right. So if somebody is being dragged unwillingly, and they are struggling, so let's assume that too,
Mhm.
you would expect items in the house to be disturbed.
Possibly.
The blood that was on the backpack that Kathy was seen wearing as she's leaving her house on September 8th. I want to talk a little bit about that. You do know that Collin's phone was found in his car,
Yes.
right? And the 911 call came from Kathy's phone, right?
Yes.
And that means that Collin had to use Kathy's phone to call 911
Yes.
because he was the caller.
Correct.
And it's possible that Kathy's phone was in her backpack, and that Collin had to go into the backpack to find the phone to be able to make the phone call to 911.
It's possible.
The Ring cameras, you said that there were cameras in five different cameras, one an outdoor, one on the doorbell area,
Yes.
right? Then one in the living room,
Correct.
one in the kitchen,
Correct.
and then one in each of Collin and Kathy's bedrooms.
Yes.
And the Ring videos we've seen are from the kitchen Ring video.
Yes.
Camera, rather. All right, so before we get to more about those Ring videos, you could hear Kathy tell Collin to get out and not come home, correct, on September 7th?
Yes.
And she told him not to come back even if he was bawling his eyes out, right?
Yes.
And she made him or told him to give her his house keys, right?
Give her keys.
Give her
Yes.
the house keys
Yes.
and leave them there.
Yes.
And then from the living room video camera, you can actually see her locking the door behind Collin after he goes outside, correct?
Yes.
So he would not have been able to get back in that locked door.
Unless there's another key outside that I'm not aware of.
The living room video, the living room camera actually faces towards the kitchen, so it's almost the same view, but from the opposite direction.
Right.
Okay. There was a point where Kathy was waving her hand in front of, it looked like the TV, but it would also have been in front of the Ring camera.
Yes.
Right before she says, and it's all being recorded on my Ring video.
Yes.
Okay. So she clearly knows how to make sure that some things are captured on that Ring camera.
Yes.
Now, the clips that were shown to the jury both yesterday and today, those aren't everything that happened from September 7th and September 8th, are they?
No.
I'll get to those in a minute. I'm sorry I'm not being very organized here, but before I get to those Ring videos, I want to talk a little bit about the text messages. Okay, so this is sort of a different version of the text messages between Kathy and Collin. It's been marked as Defense Exhibit 3. I'm going to approach and see if you recognize it. It's just in a little bit more readable format.
Thank you. Yes, I recognize this. Yes.
And even though it's not my case, I'd like to admit into evidence Defense Exhibit 3.
Any objection?
No objection.
It is received.
All right. I'm going to talk about some of the things that Kathy told to Collin over text message. Okay, so can you see it on your monitor as well?
I can.
Okay, so
It's easier to read on this one.
on the bottom one from September 7th at 7:01 p.m., she talks about wanting him to return the cell phone and the MacBook that were purchased for his education. Then she said, you don't have permission to be at work, which is a probation violation because you refused to do your chores for the day. Are you aware of any probation condition that required him to not be at work?
No.
Okay, so obviously not an accurate statement, right? Then she says, you violated your probation by having physical contact with me. It implies that that happened right before he left, but there was no physical contact that you saw in any Ring video that you've reviewed, right?
No.
I'm in fear for my safety and the safety of the vehicle which you took in, which is in my name. I am canceling the car insurance policy until you are 18. You may not drive the Jetta as long as my name is on the title insurance. So right there, she's telling him it's illegal for him to drive his car, right?
Right.
But then she turns around and says, drive home right now or you're going to be in trouble.
Yes.
Do you know if she ever did cancel his insurance?
I do not have proof that she canceled his insurance, no.
Do you know anything about the title to the car, whose name it was in, anything like that?
I believe it was in Mom's name, and I think Collin's name was on it as well.
So both people's
Yes.
You are being withdrawn from college as you've shown yourself to be capable of be capable of taking care of chores around the house, and then she lists them. So she was going to prevent him from continuing his college education over chores. At least that's what she claimed.
It appears that way in text.
Okay, that was it on that one. Here it says that it's 8:28, I'm reporting the Jetta stolen. You can't drive the car without insurance and without parental consent. Do you know if she ever reported the Jetta stolen?
I don't have proof of that, no.
And was it even stolen?
No.
Because his name's on the title. And then she talks about communicating with Detective Lacey. You're aware that he had been communicating with Detective Lacey Zanoniani and that she encouraged him to stay at Susan's house.
Yes, through text message.
And Kathy actually talked with Detective Lacey by phone on the 8th before she went to Auburndale, right?
Yes.
And Detective Zanoniani told her to stay home, you don't need to go up there, let Collin stay with Susan.
I don't know if it's those exact words, but something of that context, yes.
Then, right here, Kathy is threatening to close his Bank of America account so he doesn't have access to, say, money to put gas in his car, right?
Well, I don't know the reason, but it is saying I am closing your bank account since it's tied to my name.
The top message talks about how Collin's probation paperwork says he cannot leave the county without her unless it's for school. There is a screenshot of the pink paper that we talked about that specifically says he can leave the county to visit his grandmother, Susan Detman, right?
Yes.
Okay. And you're aware of the 751 plan that existed between Susan and Kathy where each could have custody of him and it would be perfectly legal?
Yes, I'm aware of it.
I'm going to approach and show you what's been marked as Defense Exhibit 6, 7, 8, and 9. You may not recognize them, but take a look. See if you do.
Thank you. So this would be the 751. This is the first time I'm seeing it, but I'm aware of it. Yes, ma'am.
Judge, I'd like to admit into evidence those exhibits I just mentioned. It's the signed paperwork filed with the Charlotte County Clerk of Court, so I think you could take judicial notice of them as well.
Any objection?
No objection.
They are received.
Okay, I'm going to publish them then. So the first document is a co-petition to establish temporary custody of minor children by extended family. And you would agree that it was signed and notarized by several people, right?
Yes.
Including Collin Griffith and Susan Detman.
Correct.
The next document is entitled Agreement and Consent to a Petition under 751. Also signed by Collin Griffith and Susan Detman, along with attorney Jeffrey Ratkin.
Yes.
And that was Defense Exhibit 7. Defense Exhibit 9 is the acknowledgement of service of these documents signed by Catherine Griffith.
Yes.
Okay, and that was December 10th of 2023?
Yes.
And then the final document, which is Defense Exhibit 8, so out of order. It's an order granting the joint petition. Signed by Judge Mary Evans on, no, it doesn't say. What was filed. I thought it said it on here.
I think it's under the signature.
Okay. It is. I can't read it.
January something of 2024, I believe.
Yeah, thank you, everyone. January of 2024. Okay, suffice it to say that everybody was on board with both Susan and Kathy being able to make decisions for Collin and have custody of him.
It appeared so, yes.
Oh, yes, the pink paper with the permission to be out of county to visit the grandmother. It says that we'll notify Monique. You're aware that Collin did in fact notify his probation officer by email
Yes.
that he was going to Susan's.
Yes.
And it was a weekend, so she wouldn't have answered the phone at her
There
office.
wasn't a response.
And then Kathy says that she's going to call the police and send them. She didn't ever call the police that you know of to send them to pick Collin up.
Not to my knowledge, no.
Okay. Then there's some texts about selling his car and it's right here. Is that where it was? Okay, here we go, second one, where she claims she had gone up to Auburndale, tried to get into the community, the gates wouldn't let her in. She's at the dealership in Lakeland, all this elaborate explanation of how she's going to get rid of his car, but none of that was true either, was it?
No. Not that I'm aware of.
Well, we see her on Ring Video at
Correct.
all hours up until mid to late afternoon on the 8th,
Right,
right?
and that was at 10:54 a.m.
Here she talks about Epic Towing, so she even comes up with the name of a tow company that's going to go pick up the car, and a specific amount of time within which they'll be there. That wasn't true either, was it?
I don't have proof that she called a towing company, no.
Or that a towing company showed up
No.
in Auburndale.
I don't have proof of that, no.
So suffice it to say, a lot of the things that Kathy claimed were just simply untrue.
Empty threats, yeah.
Are you aware of some texts between Kathy and Collin in late August of 2024 where she tells him that she's feeling down again and is maybe going to go into a facility for a while?
Yes.
Okay, so I'm going to approach and show you what's been marked as defense exhibits 4 and 5.
Yes, I'm aware of that. Yes. Yes.
And they appear to be the text from Kathy to Collin.
Yes, it does.
I'd like to admit into evidence defense exhibit 4 and 5.
Any objection?
No, Your Honor.
They are received.
Publish them real quickly. So down here on 724, no, that's not the one. Oh, that was the one. So it wasn't a week or so before. It was over a month before. But she's telling her son, just so you know, I'm not doing so good. I just had a long conversation with my mom, and she was basically my mom. And she told me that she has stage 3 cancer. She's in Georgia, and she's not going to help me with DVC. Do you know what DVC is? It's a Disney Vacation Club.
Oh, I know what that is, but I didn't know the abbreviation for it.
And that she could care less, and so in response I got really upset and quit my job. And sorry, so this was not related to her mental health. It was about her quitting her job. Are you aware that she actually quit her job or did not quit her job?
I'm not aware. I don't have proof she quit her job.
And then also on July 24th, Kathy talks about how she sold the house, and that this story about how somebody has assumed the mortgage and she was going to move out. Any proof that any of that was true?
No, ma'am.
And on Defense Exhibit 5, she says that she spoke with Dr. Goldstein today, and Dr. Goldstein wanted Kathy to go to an inpatient facility for some time, and that she was thinking about doing that. So that's what we were talking about Kathy communicating her mental health issues with her son.
Intensive therapy, it says, yes.
But inpatient for 72 hours or so.
Yes.
The Ring videos that were played, you already said they didn't include everything that happened that day. There are actually some parts that I wanted to see if you remember seeing. One is from September 7th, where Kathy is trying to get a lid off a cup. Do you remember that part?
Vaguely.
And she then starts yelling at Collin and blaming him for cutting her hand.
Vaguely.
Okay.
I'd have to see it again.
Okay, well, that's what I'm hoping to do. This is Defense Exhibit 10. Do you have any objection to it?
No, it's
Judge, I'm going to publish just,
offering it?
yes, I'm offering it into evidence, Defense Exhibit 10. It's a portion of the Ring video from September 7th, 2024.
You have no objection.
I don't object.
It is received.
And I'm only going to play a portion of it because a lot of it duplicates what has already been shown.
Okay, definitely not Collin did. fucking tight. I can't even get the fucking lid off. I just cut my hand. Jesus Christ. I'm a full-blown sweat from trying to open a fucking cup.
In that clip, does it appear that Kathy actually cut her hand?
Doesn't appear so.
And then finally, on September 8th, we saw a lot of clips of Kathy on the phone with a variety of people, right?
Yes.
Do you remember a portion that was left out of the exhibit that was already entered into evidence where Kathy says it's not about to be a threat, it's about to be real, shortly before she leaves the house?
I think that was played. I think that was played from the kitchen. There's two areas that you can get that same audio from, the living room and the kitchen. I think that was played.
Okay. Well, I'm going to play it again just in case.
Yes, ma'am.
But this is Defense Exhibit 11 from September 8th. I would like to offer it into evidence and just play a portion of it.
Any objection?
That's fine.
It is received, excuse me.
Thank you. 2130.
How he's better off at your house, where he's killing people, pretend, and making fun of it, and kidnapping them, and having them tied to little chairs while he tortures them and kills them with other people in this games area that he has. I sent you the pictures.
It's 2130. That's okay. That's good.
It's not about to be a threat, it's about to be real.
And I apologize if that had already been played.
Yeah, it was played on the other one.
Detective Peters, when you were shown pictures of Kathy and Collin on various trips, you said that they appeared happy. In some of these clips and in some of the text messages that the jury's seen today, Kathy appears quite angry, correct?
Yeah, she appears frustrated. Yeah, angry.
Angry? And it was in that state that she left her house and went to Auburndale against advice from several people, right?
I don't know who the several people are, but she did leave at that time to go to Auburndale, yes.
And she was yelling on her way out the door.
Yes.
But you're aware that several people told her not to go to Susan's house and to let Collin stay there.
Detective Lacey, yes.
And Susan.
Susan,
Yeah. So at least two people.
yes.
But she ignored them.
Yes.
I don't have any other questions, I don't think. If I could have one. Nothing else?
Redirect,
Nothing further, Judge.
is the witness released?
Yes, sir.
For
today.
For today.
All right, if you're needed back, you'll get a call.
Yes, sir. Thank you.
Mr. Levine?
Judge, that will conclude the witnesses for today.
Ladies and gentlemen, we're going to break for the weekend. Remember not to start to think about how you might decide the case. Again, you cannot talk about the case or look anything up. Remember to be careful with the news. Enjoy your weekend, and we will see you Monday morning at 8:30.
All rise, please.
May be seated.
Anything before the weekend recess?
No, Your Honor.
No, sir.
All right, everybody, enjoy your weekend.
Thank you.
Well, guys, today's the last day in January. The state supposedly is going to be ending their side on Monday. So I want to wish you all a fantastic weekend. I'm not going to do an overview. I've got a lot I need to tend to on my end. Please join us back on Monday as the trial continues for day 4 in the Collin Griffith trial. If you missed it, please replay. And also, we have days 1 and 2 already set in the playlist. Y'all guys have a great weekend, and we will see you soon.